everyone. Welcome to the first day of our oral argument session here in the Harrisburg courtroom of the Supreme Court of Pennsylvania at our majestic state capitol building. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America, and our roots date back to William Penn's Provincial Court of 1684. Our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722, and in 2022 we celebrated our 300th anniversary with a special session in Old City Hall. We are proud of our rich history, and we're still here. Attorneys who have argued before this court are aware that I like to point out some of the splendid works of art displayed in our magnificent courtrooms. First, as you may have noticed, regrettably, this courtroom is not in its usual pristine condition. In July of 2020, we noticed water damage to the intricate plaster work that adorns the northeast corner behind the bench. Since that time, our Supreme Court Administrator, Chris Nace, and our court crier, Brian Minner, have diligently worked with the Department of General Services and Capital Preservation, the Capital Preservation Committee, through its Executive Director, David Craig, to address the water intrusion in what you can imagine is a daunting process in such a historic courtroom. Following extensive repairs in 2023 and 2024, the court made the difficult decision to remove the damaged surfaces and allow the underlying masonry to dry. Thus, you will note that Moses has come down from the mountain. He's no longer in his normal spot. While we are optimistic that the exterior work resolved the issue, additional efforts may be necessary to prevent water from intruding into this space, and our court administration will continue to work diligently to restore this artistic treasure of the Commonwealth to its original grandeur. As architect Joseph Houston envisioned this building to be a palace of art, I encourage everyone in attendance to visit the rotunda, the legislative chambers, and the governor's reception room with an eye toward the beautifully created artwork, particularly the famous Violet Oakley murals installed throughout this courtroom in 1927. Violet Oakley was the first American female artist to receive a major public art commission, and she devoted over 25 years of her life to this project. Her murals on the evolution of law in this courtroom are simply spectacular. In 1927, Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium. When your case is called, I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. Finally, while we have no set time limit for your argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time I will ask that you conclude your argument. Mr. Minner, please call the first case.
Samsung Fire and Marine Insurance Company versus the RI Settlement Trust. Representing the trust, Mr. John Ellison. Representing appellees, Mr. William Salzer.
We have agreed to address two questions certified to us from the United States Court of Appeals for the Third Circuit. The first question is whether Pennsylvania recognizes an overriding public policy against sex trafficking, comparable to the one we identified in Minnesota Fire and Casualty Company versus Greenfield, that may abrogate an insurer's duty to defend and indemnify an insured when the insured is alleged to have enabled or knowingly profited from sex trafficking. Assuming that such a public policy exists, the second question we have agreed to address is whether in such situations an insurer's duty is abrogated only when the insured's alleged conduct was intentional or is a lesser mens rea sufficient. Please proceed.
Good morning, Your Honors. May it please the Court. John Ellison from the Reed Smith firm, along with my partner, Luke DeBevick, on behalf of the RI Settlement Trust and the other entities that have been rolled into the trust as the result of the underlying bankruptcy. I will refer to them collectively as either the policyholders or the hotel defendants. These two certified questions derive from a decision by Federal District Court Judge Kenney that denied the claims for coverage that our clients had made under insurance policies related to 4 underlying lawsuits pending in the Philadelphia Court of Common Pleas, not on the basis that the allegations in the underlying complaints do not trigger coverage, but solely on the basis that Pennsylvania public policy prohibits the insurers from providing the coverage that they sold to the policyholders that relates to the years that, under which the claims by the underlying plaintiffs have been made. Judge Kenney construed the negligence claims that are pending in those complaints against the policyholders as alleging solely criminal conduct that violated the state's anti-trafficking law, and therefore held that there was no coverage available because of Pennsylvania's public policy that is reflected in that law.
Could I stop you there for just a moment? I've looked at the complaints, and we're talking about negligence causes of actions in each of the counts. Is that correct?
That is absolutely correct.
So if there's criminal activity, it is alleged to have been perpetrated by others. The hotel's liability is entirely premised on negligence. Is that correct? That is
the way the claims are pled, and that conclusion, Your Honor, I agree with 100%, is confirmed by the amicus brief that was filed in this action by the plaintiffs and their counsel. When they, and I'll read, I wanted to read a quote to you from that brief, which is at page 13, where they said, maybe the district court believed that such conduct should expose the hotel defendants to criminal liability. But these are the initials of the plaintiffs. But MB, CA, BH, and KR did not state factual allegations of criminal activity or seek compensation for any crime committed by the hotel defendants. They sued them for negligent failures and omissions with respect to preventing others from committing criminal activity.
That's what I saw in the complaints, and there were some additional negligence counts, such as negligent infliction of emotional distress, but all of the counts sounded in negligence.
Exactly, and they all derive from allegations of failure to train the employees properly, failure to supervise the activities of the people who rented rooms at what was a lawful hotel business.
But that would be the defendant's conduct. That would not be some other person's conduct. The negligent supervision, negligent training, that would be conduct of the defendant, albeit negligence.
Yes, but of a negligent variety.
Correct.
There was no claims against any of the hotel defendants for any intentional conduct whatsoever.
So any underlying criminal conduct is alleged to have occurred by the people who were taking part, the traffickers, and are not being blamed at this point, based on the allegations, on the hotel.
Correct.
Okay.
And I think, Your Honor, that's where the intersection of the Greenfield and the Moore cases meet. And in Greenfield, we had a very clear situation where the perpetrator of the criminal acts, the person who was selling the heroin, who was a drug dealer, was asking to obtain coverage for claims being made against him related to his drug dealing activities. Purely intentional conduct, conduct where the drug dealer had already been convicted of a crime and admitted to essentially killing the person whose estate was suing him. And in the,
I'm sorry, which case are you
Greenfield,
referring to?
the Greenfield case.
Yes.
But even more so, the victim in that case was in para delicto,
Right,
which was the basis for Justice Saylor's joinder.
exactly.
Let me ask you something, and I understand the underlying complaint as you do, but that does not appear to be what Judge Kenney found. And so I struggle with the certified question that we have for that reason. I mean, all of us are used to seeing these cases where we have before us the complaint. We have before us the ultimate question, the first question, which is there any way in which the policyholder can recover, i.e. get a defense? We don't have this here. We have a question that says, if we find X, then does that obviate coverage? How do we get to what you're talking about?
Well, I wanted to read one sentence to you from Judge Kenney's opinion, which was at page 15 of the opinion. He concluded, the court strains to imagine a clearer case than the one presented here, in which the facts alleged indicate that the policyholders engaged in criminal conduct in violation of the Pennsylvania human trafficking law. That conclusion, Your Honors, violates almost every aspect of Pennsylvania's insurance coverage law.
But we can't reach that. You understand the problem we have. It gets back to what I just said. This is a sanitized version of a coverage case that we would never see. I mean, you're arguing error correction. We've not been asked to really look at that, or have we?
Well, or are you arguing error correction in the premise? I mean, we can still reach the issues, can't we?
I think you can. I think in the cases that have been accepted for certification from the Third Circuit, the court has said previously that it is not only entitled to answer the certified questions, but subsidiary questions that are subsumed within those questions that need to be addressed to answer the questions that the Third Circuit has asked.
Well, and given that we accepted the petition for review, I guess the other alternative would have been for us to deny the petition for review, which we're loath to do. You know, we have a sense of comity with the federal court. If they ask us to interpret something under Pennsylvania law, we almost always say, yes, we'll accept it for certification. So since we didn't turn it down and we did accept it, maybe we should be glad that it's with us, and I think we know what to do with it.
Well, and I think, Your Honor, Justice Donahue, to also address your question, the Third Circuit itself has already taken issue with what Judge Kenney said and found. In footnote 5 on page 7 of their decision, they said, we read the underlying complaints in this case. The allegations, if proven at trial, would establish only recklessness, but under Pennsylvania law, injury caused by negligent, careless, and reckless action does not come within the exclusion for expected or intended injuries. So the Third Circuit itself has already rejected, in our view, the conclusions that Judge Kenney reached in that sentence I read to you from page 15 of the opinion.
I didn't read that way, to be honest with you. I read it as their explanation for why the district court judge didn't actually talk about the policy, which is the first place most people would start. And they're saying the policy would cover this. That's what they are saying. They are saying the policy would cover this because of the recklessness that is at most alleged in the complaint.
I think that's exactly right.
At most, but could you clarify? I don't recall reading allegations of recklessness. Maybe I just
Some
missed
of
them.
them did, yeah.
I recall negligence, but are there recklessness allegations?
I don't think there are, Your Honor.
don't recall
I think
seeing
that was perhaps an inference that the panel, the Third Circuit panel, reached from the collective.
Well, is it an inference to perhaps raise this to a criminal activity level? Because I don't see anything like that in the complaint.
I don't think it's in the complaints. I think it was their concern that because Judge Kenney had invoked the public policy issue here, the only way that becomes an issue under the trafficking statute, if we get to a level of recklessness, because that's the mens rea that's required under the statute for an actor to be guilty of a crime.
But even if recklessness had been pled, these cases are defended all the time under reservations of rights all across this Commonwealth. Why should this case be any different?
It should not. And in fact, this originally started with the insurance companies accepting a defense under a reservation of rights, and that's how it was proceeding until the bankruptcy stopped everything, and then we were in limbo.
Just on that, isn't it also correct that, maybe memory fails me here, but aren't these cases defended under reservations of rights even when there are alternative pleadings of intentional conduct?
Yes. I mean, as long as there is a claim or some facts that would trigger the coverage potentially at the end of the matter, then the defense should be provided.
But we don't even have to get there, because if there were intentional allegations of intentional conduct that could be viewed as criminal conduct, then perhaps it raises this question of our overriding public policy against sex trafficking, but we don't really even get there because we don't have those kinds of allegations.
I agree with that, Your Honor. I agree with that.
Counsel, if I could ask, I'm not sure what this opinion is going to look like that we would issue in this case. The questions that, going to Justice Donohue's point, the questions we have been asked are sterile. We're being asked a question of Pennsylvania law. That's the only reason they came back to us. They can decide whether Judge Kenney's decision was correct or not correct. For my purposes, I'm not sure I care what Judge Kenney did. I'm being asked to answer questions of Pennsylvania law, so I'm going to ask you the question. Does Pennsylvania have an overriding public policy against sex trafficking?
It has a public policy against sex trafficking.
Okay, so we agree with that. So the first part of the first question, the answer is yes.
I think that's undeniable.
Okay, so then the question becomes, can that overriding public policy defeat under certain circumstances, could it defeat a duty to defend and indemnify under our public policy jurisprudence?
Or in the alternative, do we even reach that question? Because it's not, can it under certain circumstances? Isn't the question, does it under these?
No, that, Chief, respectfully, that's not, I'm not looking at the question. Such that insurer's duty to defend or indemnify is abrogated when insured is alleged to have enabled. I'm kind of changing the question because I'm trying to go incrementally to see what you agree with. But do you agree that under certain circumstances, and we'll get to those, the overriding public policy against sex trafficking could abrogate a duty to defend and indemnify?
I think the answer could be yes.
Okay, so we agree that that could be yes.
Yes.
So what we're being asked then, I guess, is to tell the Third Circuit under what circumstances would that overriding public policy prevent or abrogate the duty to defend. And then they would take what we tell them in terms of what circumstances it would, and they would apply under the circumstances of this case.
I think that's correct.
Okay.
I would invite the court to go a little further if you would like. I also understand what you're saying.
Okay.
But I think, to answer your question, this is where I think the Greenfield and Moore cases really provide the answer. And the answer from the policyholder's perspective is, if you have purely criminal conduct that is intentional and has been either pled to be criminal or has been adjudged to be liable criminally, for which that actor is seeking insurance coverage under a policy where they're being sued for the criminal act they committed, that's against Pennsylvania public policy. I think the case that best reflects the result here is unfortunately a Superior Court case, but it's a decision in the General Accident Insurance Company case v. Allen. That case was a case involving allegations of sexual molestation of minors relating to lawsuits that were filed against a husband and a wife. The husband was the bad actor. He was the person who molested the children. The wife was being sued because she didn't prevent the molestation of the children and was negligent in not knowing what her husband was doing and horrifyingly injuring the kids. The Superior Court held, I think correctly, that the husband was not entitled to any insurance coverage for any of his conduct because it was criminal, he was found guilty of it, it was intentional, and he is the one who was the actor that caused the injury. So why should he be entitled to insurance for that? The wife, on the other hand, was found to be entitled to coverage because she was negligent in not preventing the actions, but she had not engaged in any criminal conduct of her own and was never charged with any crime, nor were any of the accusations in the underlying lawsuits against her involving criminal conduct. And I think that's the difference here.
Well, counsel, is there a safety valve to protect an insurance company from prosecutorial discretion? Let's say the prosecutors decide there's an enterprise, there's an individual involved in criminal activity, but the prosecutors choose to go after the individuals and not the enterprise. So no charges, no guilty plea, not Greenfield, where he pled guilty to multiple criminal charges. And the enterprise seeks insurance coverage. Is there some kind of a side trial within a trial or some kind of a procedure where the insured could do the duty to defend under a reservation of rights, as Justice Weck said, but somehow, some way then prove the criminal liability and abrogate indemnification?
I think that is possible, and I think that's the distinction between the duty to defend and duty to indemnify. I think in order for an insurance company to escape the indemnification obligation, they would have to prove the criminal responsibility of the actor, even if they weren't prosecuted separately outside.
Probably with proof beyond a reasonable doubt under the criminal
I would
standard,
think so.
imagine.
If they're charging a criminal offense, I think they would have to meet that burden.
Counsel, doesn't the insurance carrier always have a safety valve? An exclusion in the policy for criminal acts?
I was going to get to that.
Well, I mean, we're dancing around the obvious issue here. I mean, we're being asked to obviate coverage where the insurance carrier did not have an exclusion for criminal acts. And they could have written that any way they wanted to.
If you go back to this court's decision in the Eisenman v. Hornberger case, which was, I think, one of the original cases on this type of topic about whether public policy can preclude insurance coverage, the court made a point in that case of saying that there was no violation of law exclusion in the policy. So essentially, the insurance company is asking us to rewrite the policy and grant them an exclusion that they didn't put in the first place.
Which is exactly what Justice Cappy and Justice Nigro said in Greenfield.
Exactly, and right, exactly. But the holding in the Eisenman case was what Justice Cappy had repeated in the dissent to Greenfield. So, Your Honors, I think I've made my points. We think that the limitation that should exist is that if there is intentional criminal conduct directly committed by the policyholder for which they are
alleged to have been.
Or alleged to, for which they are seeking coverage related to the criminal act they committed, Pennsylvania public policy would preclude coverage for a case like that.
Counsel, why are you conceding an allegation? Why are you conceding allegation?
Yeah, I don't think I should have done that. Right, it's a difference between
If there is if there's proven criminal conduct,
which is what existed in Greenfield.
which is Greenfield, but looking at the policy allegations, you think that not we, of course, the Third Circuit should evaluate the allegations, or should we say, under Pennsylvania law, mere allegations are not enough?
If there are claims of negligence in the underlying complaint, then I think a defense needs to be provided. If someone
No, if there are claims of criminal conduct in the underlying.
of
Then
negligence,
I
if
didn't
there
let
was
you finish your sentence, I'm sorry.
if there were claims of criminal conduct that allege solely intentional action by the policyholder,
That abrogates the duty.
I think an insurance company could challenge a defense in that case if there's no negligence count pled.
Not the duty to coverage, but the duty to defend.
Conceding that, I mean, even the plurality in Greenfield hastened to say, however, in cases that do not involve a criminal act by an insured with respect to a Schedule I controlled substance, our decision in Eisenman reiterating the test, et cetera, retains its validity. Meaning, Justice Newman, in her plurality, which got a full jointer only from Justice Aiken,
Right.
was at pains to limit this to heroin, which is an interest. I'm going to ask your adversary about that, but I'm interested in your apparent concession that you would be willing to extend Greenfield past its limits.
Well, before you answer that, are you talking then about a duty to defend or a duty of coverage?
She's talking about both.
I know, but I'm asking, in answering Justice Weck's question, I'd like you to be clear, are you talking about the duty to defend or the duty of coverage?
On the duty to defend, I think if there is any potential for coverage, the insurance company has an obligation to indemnify. And Greenfield, I don't think could have been decided any more narrowly than it was. I mean, the court, even in the plurality, was at pains to make it very narrow.
And that is based on allegations.
Exactly.
Thank you.
So I think, to go back to the question from Justice Robson, I think unless there is proof of criminal wrongdoing that is the exclusive basis for a claim, an insurance company should be defending the case subject to a reservation of rights that it might be able to prove that a crime was committed.
But even to your point, though, let's say they allege negligence, but they also, I'm saying they, I'm not talking about this complaint, basically talking about hypotheticals. The allegations in the complaint clearly amount to criminal conduct, uncharged, unpled, unconvicted, but allegations of criminal conduct. You're saying if the complaint merely alleges criminal conduct, that the insurance company can do what? Not defend or bring a judgment action and say, we want to prove the criminal conduct and not defend?
I think that's what they should do, and defend while they're pursuing the declaratory judgment action. And that's basically, I think, the holding that comes out of Moore. Because the first act is clearly a deliberate murder when he goes in to kill the ex-wife, and then when the boyfriend shows up and he shoots him too, there's a potential that that's accidental, but that's also probably a crime, I think, to shoot somebody with a gun who's not attacking you. And in that case, Your Honors found that a defense was owed because there was a potential that it was a negligent action in shooting the boyfriend.
So
Could
then,
you go back to Justice Weck's question? Why are you willing to extend Greenfield beyond the Schedule I controlled substance? Why are you willing to do that?
I'm not willing to do that. All I'm saying is an insurance company might be able to argue if they could show some purely criminal activity that was intentional harm aimed at the person.
But that's not what Greenfield was about. Greenfield was about the most horrific, terrible crime that the legislature had ever envisioned, and it was a scourge on society, and because of that, two justices said, this is an overriding public policy. Justice Cappy, in his dissent, said, this is a slippery slope. When's the next case that we're going to have where there's an argument that there's overriding public policy? And you are conceding that Greenfield allows for that eventuality, and I'm asking why.
I'm saying an insurance company could have an argument that would fit within what the holding of Greenfield was.
See, that's what the Third Circuit is asking us. Do they have that argument?
On these facts, no.
And the answer is either yes or no.
Well, the answer
Under
is it
Greenfield.
depends.
Under Greenfield, are we going to extend Greenfield to encompass other quote-unquote egregious public policy statements? What about DUI that involves in a death? huge public policy regarding that issue. Is that the next thing that we're going to look at?
I think the
Or
answer
does
to that would be no.
Greenfield stand on its facts, period, considering it really wasn't a majority opinion?
Right, it's also not a majority opinion, so I'm not even sure it's controlling law. And I think Moore makes clear how limited and narrow Greenfield was and needs to stay. And I think that's the answer.
Isn't your answer that that's what an intentional acts exclusion would be?
Correct.
Yes.
That's
Right?
what it does.
Isn't that the cleaner?
Yes.
Isn't that the cleaner?
It's the expected or intent, right, it would fall within the expected or intended language that excludes
We
coverage.
don't need to go down this rabbit hole of what's an overriding public policy or what's just an underwriting public policy.
Right, I think that's right.
On the other hand, there may be, I don't know, but there may not be much dispute that there is an overriding public policy, in a general sense, against sex trafficking in Pennsylvania.
Right, I think that's right. But there is also a strong public policy in a whole host of decisions from this court about the insurance company's obligation to provide a defense under a policy until it is proven beyond a doubt that there's no aspect of the underlying.
That's the law. I mean, that's
That
the
it-
law that we've recognized. Yeah.
Well, and I think it sets forth a policy of how insurance companies are supposed to act in this state when claims are made against their policyholders.
Okay. Anybody have any other questions? Do you want to sum up? Or have you?
I think I have summed up, but I will just say quickly, we think both of the answers to both of the questions from the Third Circuit should be in the negative for the reasons I've stated, and thank you very much for the opportunity to.
Thank you, Mr. Ellison. Let's hear from Mr. Salzer.
Morning. May it please the Court, William Salzer of Swartz Campbell, on behalf of the insurer Aplt. I'm joined by Edward Koch of the White & Williams firm. I'd like to first address this court's role in the acceptance of the certification of the issues by the Third Circuit.
You think we're regretting it?
Well, this court stands in the role of answering the discrete legal questions that have been posed by the Third Circuit. It did not have original jurisdiction. That jurisdiction lies in the federal courts.
So we resolve the questions, it gets sent back to the federal courts, and they resolve the case.
Correct. The trust will have its day in court, in the court that has jurisdiction.
Well, they'll have
To answer-
it'll have its day in court after the Third Circuit has had the benefit of our articulation of the law of Pennsylvania.
Absolutely. But what the trust is asking this court to do is to step beyond answering the certified questions, to act as if it were the final appellate court to resolve such questions as, did the district court get it wrong in how it construed the complaint? So, for example, the issue of, are the averments in the complaints consistent with negligent conduct? Do the facts of those complaints control in the analysis of the duty to defend inquiry?
That it's not an allegation of negligence?
Well, there are two things. First, the facts control, not how it has been pled. We also know that in Greenfield, go back to Haver, those lawsuits were pled exclusively in terms of negligence. One will not find any intentional tort claims pled in those cases. In fact,
So, counsel, if facts control, as a factual matter, were any owner, operator, or employee of any of the hotel defendants criminally indicted or investigated?
they were not
That's
criminally...
that's a fact question, right?
Well, they were not criminally indicted, and most likely, I don't know whether they were investigated or not, but in Haver,
So was there any direct intentional conduct by any of the hotel operators or any of the hotel employees?
yes, I mean, those facts that are pled out make out those, make out the fact that the commercial sex trafficking was so rampant and obvious that the defendant who is charged in the complaints with knowledge of what is
That
transpiring.
should have known. I mean, that's a negligence standard, right?
Well, it was pled in terms of negligence, but we have to look at the predicate facts.
Well, you seem to be dancing around something that is glaring and obvious. There's no intentional tort pled in the case. Are you trying to tell us that that's not the case?
No, I'm not. There is no intentional tort pled. What I'm saying,
You issued a reservation of rights letter, and then, you thought better of it, and you thought you'd take an aggressive position and deny. I'm curious as to how that evolved.
we've defended the insured at all points until such time that a court ruled that we were relieved of that obligation because the facts, if accepted as true, which is the standard of the duty to defend an inquiry, made out claims that in the district court's opinion would violate Pennsylvania law, Pennsylvania public policy, because the duty to indemnify carries a conditional the duty to defend carries a conditional obligation to indemnify. And if you do not have an obligation to indemnify based on the facts pled, you do not have a correspondingly duty to defend.
But how
The
does that-
insurers defended until such time that we were relieved.
How does that duty to defend jurisprudence apply in this public policy exception, assuming we extend it in Greenfield? Because when you're talking about criminal conduct, no one, a mere allegation, and that's the part of the Third Circuit's first question, is abrogated when an insured is alleged to have enabled or profited from such trafficking. Not proven, not established beyond a reasonable doubt, not even established by a preponderance of evidence, not even put in front of a jury, a mere allegation. How can that be true when you're talking about not a duty to defend in terms of did this happen during a claims made period on a claims made policy and all this other date and time and things like that? This is more substantive than that, driven by jurisprudence from this court. Why is a mere allegation enough under this broad public policy exception?
Well, the facts pled have always driven the coverage analysis, as opposed to
Not on public policy exception.
Well,
not on overriding public policy. At least I didn't find one. In Greenfield, he pled guilty. He pled guilty to multiple criminal offenses for which he sought coverage.
If we go back to Haver, there was some discussion of that very fact, where in a footnote the court said that the fact of the guilty plea was immaterial to the analysis. It was extrinsic to the complaint, and whether or not they had pled guilty would not dictate whether there was a defense obligation.
So what happens to innocent until proven guilty? What happens to why not put your claim in front of in your deck judgment action? Prove that they committed criminal conduct, and then you'd be out of get out in Greenfield, assuming we extend.
Once again, the analysis. Well, if I may, in Greenfield as well, the fact of the plea in that case was not pled out in the complaint. In fact, that was information that came in extrinsically. It was not central to the court's holding. And I think if we look...
You say that wasn't central to the court's holding, that guilty plea of Mr. Greenfield to the heroin dealing. You're telling us that that wasn't central to the holding.
It was the fact that in the complaint, the insured is charged with having delivered heroin to the decedent,
Okay, so the
which
overriding public policy was against the heroin distribution, right?
Yes.
And here you want to say there's an overriding public policy against sex trafficking, although the hotel owners were not accused, much less pleading guilty to sex trafficking. Am I correct?
Yes, we are saying that the overwhelming public policy is that when there is obvious commercial sex trafficking that is taking place, and it is alleged that the defendant knew and was financially benefited from this. I mean, the complaints say that your traffickers paid cash to the hotels. That facilitates the trafficking activity.
Do we have an overriding public policy against murder?
Yes.
Okay. Well, I know you were counsel for amicus in Baumhammer's. You
Yes.
remember the Baumhammer's case?
Yes?
Baumhammer's went out and murdered racial and ethnic minorities. His parents claimed coverage under their policy, and they got it, although you argued that they shouldn't get the coverage. We have an overriding public policy against murder. Why is that policy less overriding than a policy against sex trafficking?
Well, first,
Or a policy, there was a Steelers game on Sunday. There were all kinds of tailgaters. I'm sure some of them got drunk. What if one of them got in a fight and hurt somebody badly and the Steelers got sued? Would you say, well, we have an overriding public policy against drinking in the parking lots, you don't get coverage? I mean, where does this end? Isn't everything in our crimes code an expression by the General Assembly in this building that Pennsylvania has an overriding public policy against that conduct?
multiple good questions. First, Baumhammer's. The homeowners had not committed any criminal act. There are no facts that were pled in Baumhammer's that charged the parents of their son who had committed the shooting spree with any conduct that would have violated a criminal statute. Here, by distinction,
Well, they were negligent allegations in the Baumhammer.
yes, there were negligent allegations, so they should have told the authorities that their son
Should have
was
supervised their son.
unstable. They
So
were aware that there was...
compare it to this case.
I'm sorry?
And you're going to say, and so in this case, in contrast, what?
In this case, in contrast, we have the fact that the traffickers paid the hotel cash for
No,
the...
they paid the hotel manager, they may have paid the hotel desk clerk.
No, they-
You sued the corporate defendants, correct?
Correct. They financially benefited, right, from acts that facilitated the activity of sex
That's-
trafficking.
That's the allegations.
That is the allegations,
There's
right?
no
So-
facts.
Well, they're correct, but this is...
No, I mean, of
We-
course, they couldn't keep their doors open if they're not getting paid for the hotel rooms. If I'm operating a parking lot, and I take money for the parking lot, and then some teenagers have a party in my parking lot and somebody gets drunk and gets hurt, have I profited from these assaults?
But there is no statute which speaks to the parking lot having any culpability for profiting by having collected money from people that park their cars, and then there's criminal activity on the premises. This case is distinct from a negligent security case in which a premises owner is charged with having failed to prevent a foreseeable criminal act on its premises. This is
But I
not
thought
that
the-
case.
I thought the allegations in this complaint were like precisely that. Like they failed to train, they failed to supervise. I mean, that's exactly what the allegations as to the corporate defendants were. I mean, take out the lower level individuals who were employees of the corporate defendant. There's a step between those people who, as alleged, did many things that should have been a clue to them that there was sex trafficking taking place. But you're one step removed from that. I mean, the allegation against the corporate defendant has to be that they should have known. I mean,
Well, the allegations are that they knew, and they knew by and through their agents, servants, and employees.
Do you think
But
those plaintiff lawyers would have refrained from pleading intentional torts if they had a shred of evidence of intentional torts? Think of the measure of damages they could seek. I mean,
I can't speak to-
Aren't you improving on their complaint?
I can't speak to what their stratagem might be with regard to the drafting of the complaint. But I think we're all coming back to the same question here, right? Which is, and I appreciate that, you know, certified questions are probably not the common thing that happens, and but it ultimately is for the Third Circuit to decide whether the district court, right, did not give sufficient weight to what you are referring to as mixed allegations, right, of negligence or reckless or knowing conduct, right? Because
Mixed. We're not referring to them as mixed allegations. I thought there were only allegations of negligence.
well, I think that the facts pled that the defendants had knowledge of the indicia of sex trafficking that was prevalent in some cases going on for years, and that with that knowledge, they did not report or stop the trafficking activity meets that reckless disregard standard. Remember, the district court had concluded that the hotel harbored these persons, right? That was one.
Saying that all over Pennsylvania, right today in courtrooms around Pennsylvania, are you denying that carriers are defending cases like this under reservations of rights where there have been pleadings of recklessness? Are you telling me that because if that's the case, things have really changed a lot since I was in those courtrooms. My recollection is that defense lawyers are defending under reservations of rights all kinds of allegations which go beyond negligence, which is all you have here. Have things changed?
No, things have not changed, right? Carriers do defend cases where there are mixed claims of excluded and non-excluded conduct. The carriers in this case defended until such time that we had a ruling that there was no coverage. The public policy issue that is at stake here, right, is something that essentially is an antecedent, meaning that if you even wanted to provide coverage for the insured's liability based on these allegations, you would not be able to do so because it offends public policy, right? That we look at the statute, right, to glean what is the public policy. And the point here is that if hotels have the ability to essentially pass the buck to insurance companies for their liability for condoning sex trafficking on the premises, this undermines the central purpose of the statute.
Well, speaking of passing the buck, they passed the premium buck to you. You were happy to take the premium. Why didn't you just impose the exclusion that existed in the umbrella policy?
Yes.
Public.
You have an existing exclusion available to you. You take it off the shelf. You put it in your policy. If they say, well, you know what? We're going to go to a different carrier because we're not living with that exclusion. You didn't give them that option. You took the premium. You didn't put the exclusion in. And now you bring a deck action to say, we want to get the exclusion provided judicially that we didn't ask for contractually.
Well, public policy would not allow you to write the coverage to begin with. So whether there is an exclusion or not is immaterial to the analysis in a public policy case, and that has been the case in any public policy decision. So, for example,
why do most of the insurance policies we see then have the exclusion?
have the exclusion
criminal
for
exclusion.
the criminal act exclusion?
Just belt and suspenders?
Well, yeah, I mean, it is belts and suspenders, but the fact is that even if you do not have a criminal acts exclusion, if it would violate public policy to provide coverage for the acts, you do not have insurance, irrespective of it. Every public policy case, right, that has been before the court involves a situation where there is not a criminal act exclusion.
Counsel,
And in this,
So I'd like, you know,
let me ask you this question. So there's these allegations of, let's say it's mixed allegations, negligence, straight up negligence, and some of the knowing benefiting, the knowing or recklessness. Let's just assume, again, I'm thinking in hypotheticals, not in this case. And we say Pennsylvania law is mere allegations of facts that could result in criminal charges and perhaps even a conviction. It would violate public policy to allow insurance companies to defend those cases. Okay, you're out. Case goes to trial. And the plaintiffs decide not to pursue their knowing allegations or recklessness allegations and purely pursue negligence. What happens with coverage at that point in time?
Well, the complaint controls. I mean, it's, if you're saying if the
No, I'm
plaintiffs were
past the
to
complaint.
file an
You're
amended
now-
complaint,
All of a sudden, the plaintiffs at some point in time say, we can't prove this knowing recklessness thing. We can't prove it. We pled it, but we can't prove it. We're going straight on negligence. Here we go. What happens with coverage?
the duty to defend has always been measured by what's alleged,
You
not what's
say that.
proven.
You
So
say
if,
that, and
if an amended complaint were filed, and
Counsel, you
this
say
does happen.
that, and I have never seen it applied in the way that you're asking it to apply. The duty to defend is, when I see duty of defend, you're talking about, was the car insured by the policy? Was the driver insured by the policy? Did the claim arise as a claims-made policy and occurrence policy? Was it properly given notice or things like that? Those you can glean from the complaint. They're pretty much, factually, this is when it happened. You're asking us to take an allegation that that is not by a prosecutor. It's by a plaintiff pursuing a tort recovery, and you're asking us to extrapolate that into an actual criminal charge that would result in a conviction. To deny to say you don't have to cover under some dominant public policy. That's different than the duty to defend rubric where you're talking about where the four corners of the contract control.
Well, I respectfully disagree. I mean, I would say, that the facts drive it in your situation, the scenario, if the proofs weren't made out at trial to rise to the knowing conduct, it would not have a bearing on the coverage determination. If an amended complaint had been filed and changes the facts that are alleged, well, that's a different issue, right? Because the amended complaint supersedes the prior complaint. But until such time, it's what's pled out in the facts that drives it, as opposed to what ultimately turns out at trial to be having been proven.
Could you clarify something for me? Are you arguing that I know you're arguing there's no duty of coverage, there's no coverage, but are you also arguing that based on these complaints, there's no duty to defend?
That's right.
You're arguing both?
That's correct.
Let me ask you the
Wait,
implications.
could I get the rest of that answer? And tell me why you're arguing both, based on the allegations of the
We've argued that based on the factual allegations, which is what the district court had concluded, and in fact, the Third Circuit, quite frankly, in its premise to the certification, likewise had concluded that those facts established knowing and or reckless conduct, and then that created the question posed to this court as to whether that sufficed. But yes, the answer is yes.
Okay, thank you.
And that's a question the Third Circuit asked us to decide, duty to defend or indemnify, correct?
Yes. I mean,
Let me ask you something else about this.
Yeah, I think Justice Wecht had started a question, yeah.
The question I was starting to ask when I interrupted the chief was, maybe Judge Kenny didn't have to worry about this, but we as the Supreme Court of Pennsylvania have to worry about ambling down this road of identifying, quote, overriding public policies. The plurality, the narrow plurality in Greenfield has this heroin thing, okay? You want it for sex trafficking, albeit you've got no guilty plea here. We have a horrible sex trafficking problem. We have an even more common problem of abuse of children and abuse of elders, okay? So what's to say if you prevail that the next case, a facility, a big nursing home that had one rogue employee that they should have known was abusing elderly, next thing you know, the carrier is going to be able to deny them the coverage that they've been paying millions of dollars for, or the big daycare facility, there's an allegation that they should have known there were somehow indicia that some rogue employee of theirs was abusing children. All of a sudden, their millions of dollars of premium are out the window too, because now this precedent will allow you to deny coverage there. Where's the end of this slippery slope?
well, I think that the court in Greenfield did the correct thing. It cabined its analysis to the discrete issues before the court. We're not here before the court to say that Greenfield is precedent binding this court to find in our favor. Greenfield provides the framework, the guidelines, right, to how to make a decision with regard to public policy. And each case has to be viewed on its merits in terms of looking at the statute, looking at what the public policy of the state is, looking at how a ruling that coverage would be afforded would affect that public policy. And so it's a case-by-case determination and requires analysis of whatever statute is at play in that particular case. And so I think Justice Donahue referred to DUI, right? And so, for example, in DUI, we would be looking at the purposes of the financial responsibility law, right, which is to make certain that there is insurance for drivers, and we have to look at the motorist public in terms of what their expectations
are. And for the victims of their negligence, and for the victims of their torts. And that leads me to my next question. Greenfield, Justice Newman's opinion in numerous places, Justice Saylor solely joined that opinion because the victim in that case was in pari delicto. I mean, one could argue that the decision in that case would have been the same had there been no public policy recognition, because the victim's estate would not have been entitled to recover because she participated in the crime. So when we're looking at these issues of public policy, don't we indeed have to recognize that one of the purposes of insurance is to assure that victims are compensated?
The purpose of the tort law is to provide compensability, right, to injured parties. But the purpose of insurance is risk spreading. So what we're really asking here from the standpoint of the public policy standpoint, which is it appropriate to say that the liability of the hotel can be borne ultimately by the insurers and their policyholders for the conduct that's alleged? There are always, unfortunately, there are always victims in cases involving insurance. I mean, we wouldn't be here, whether it was in Greenfield or in Haver or in any case, unless there was an injured party.
That point, sorry to cut you off, I just wanted to jump in here. I'm always concerned when we get a question that comes to us strictly on the aspect of public policy, particularly in a circumstance like this, because it's landed on our plate purely on a public policy forum. So tell me why would it be harmful to you for us to say no, for the reasons expressed by my colleagues, Justice Donahue and Justice Wecht? We're not going to extend Greenfield on a theory of public policy to your case. You still have all your tools based upon insurance contract to argue that you are not obligated to defend or indemnify this claim, aren't you?
Well, yes, in the abstract, that's correct. In fact, the district court did not, if I recall, reach the contract questions because the court concluded that as a matter of public policy, coverage could not be afforded based on these facts under any circumstance.
And you've argued the Moore case, and that was purely decided upon the allegations of the complaint and the language of the insurance contract.
Well, Moore, I would submit, is not a public policy case. Moore was purely a question of whether there was an occurrence, an accident, and therefore the factual allegations of the struggle and the shots being fired in all different directions and the insured acting incoherently, all those facts, it suggested to the court that there was a potentiality for an accident. So the court didn't need to go into the public policy question, which is whether the statute and what can be gleaned from the statute is an impediment to insurance coverage.
Well,
that answers the question, I'm not sure.
Public policy decisions, especially in the arena of insurance coverage, is a very slippery slope, as Justice Wecht has said, and it's not like you're you have a table of options like, oh, let's jump into this public policy. It's just not out there in most cases. And maybe you have one here today, and maybe you don't, but you do have the facts of the complaint, and you have your insurance contract, correct? That's my
Yes,
point.
but, you know, the certified question to this court is the public policy issue. I mean, and we submit that any decision by the court on this issue is limited to what is being put before the court on this, on the public policy involving sex trafficking. It's not to suggest, just as in Greenfield, that it would be applied to other situations involving a nursing home or some other types of...
Isn't that the same thing that Justice Newman said in Greenfield? This is
Yes.
just going to be with heroin.
Right, that's right. And I think that was the right to call. That was the right decision. The court should not stake out public policy issues broadly. The court should look at the facts and the statutes
Well,
and
but
the interests.
that's problematic, because the Third Circuit specifically asked us to say, as found in Greenfield, which we certainly have the ability to look at Greenfield and say, you know, a little dicey there. I have a straightforward question, maybe. Tell me how I am to determine which criminal statutes amount to overriding public policy versus regular public policy.
I think the real question is, when you look at this statute, the legislature enacted this law in 2014, in my view, to follow the money, which was not to simply impose liability on traffickers, but to reach those that profit and that facilitate sex trafficking. And then they went further in 2020 in the Buyer Beware Act to impose criminal culpability on the buyers. Right? It is a long-standing effort of the legislature to take steps that are necessary to eradicate sex trafficking. And if
So extrapolate that into a standard.
and the standard is that if to provide coverage,
No. The standard under which I'm supposed to look at a criminal statute and determine whether, because that's what the General Assembly does, they make public policy. So a criminal statute is, by definition, the public policy of the Commonwealth of Pennsylvania. So I guess my question simply is, taking your example of this statute, what is the legal standard or principle I am to apply when I look at a criminal statute and say, oh no, that's just public policy, not overriding public policy?
well, I guess that's a good question, right? How to distinguish between public policy and overriding public policy. And I think I would submit that when we're dealing with sex trafficking, which is a public welfare epidemic, when we're dealing with the fact that even efforts to outlaw trafficking has not stopped the problem, where I think there is an intent to, as I say, follow the money.
Okay, so
Can you
extrapolate that, because that's the same answer you just gave a few minutes ago. Extrapolate that into a standard that I can move to other statutes.
Well, I guess I think the big standard is this, which is the question is whether relieving the defendant of, we'll call it personal financial responsibility, right, will undermine the goal and purposes of the statute, right? I think that gets to the heart of it, and I think...
Why is that relieving the defendant? They contracted with your client for a policy of insurance. And why isn't the answer to Justice Brobson's question that it's simply a fool's errand to distinguish between an overriding public policy and a mundane public policy, because we have an entire crimes code that we're not going to be able to pick apart to delineate which ones are going to be escape hatches for carriers?
Well, I think, you know, if you look at Central Dauphin, the decision there, right, where the issue was there was an unlawful tax levy, and there was liability, and the entity looked to its carrier, right, for insurance for the violation, and the court said, well, if we were to do so, we would essentially, subsidize unlawful activity. The entity would be able to financially profit from issuing an unlawful tax levy. The statute says the money should be returned to the citizenry. And if the entity, municipal entity, can just turn to its insurance company, it defeats the whole purpose of the law.
But the insurance carrier can protect themselves from all of the horrors that you just described. The insurance carrier that wrote the umbrella policy in this case appears to me to have looked at the statute at issue in this case and said, we're going to preclude coverage for anything that involves abuse of minors, anything that involves negligent investigation of what's going on in the facility. I mean, it's a specific exclusion dealing with precisely what we're talking about here. I mean, your companies, the Resolution Trust defendants, whatever the entity is called, they could have protected themselves from this eventuality. They did not. I mean, maybe they did. I mean, I don't know what remains pending in the DEC action. I mean, there's certainly incidental acts, and there probably is intentional acts exclusion. But why would we get involved with this? We have defendants, policyholders who paid for coverage. We have a situation where it's apparent that some insurance carrier foresaw precisely what happened here. Why would the Supreme Court of Pennsylvania get involved with redrafting an insurance policy?
Well, the violation of law exclusion or criminal act exclusion, right, is, I think I said earlier, sort of a belts and suspenders, because insurers are not contemplating that they are insuring a risk that an insured is engaging in conduct, right, that undermines our state's laws. In Greenfield, there was no violation of law exclusion in the case, nor was there one in Haver as well. In fact, I think, in Haver, there was the knowing endangerment exclusion, but the court felt that it was important to emphasize that in the face of the arguments that the exclusion was ambiguous, that it would be against public policy to provide insurance for criminal or evil conduct. So I think there is this, the initial concept is that...
You shouldn't have to protect yourself.
I'm sorry?
The concept is the carrier should not have to protect itself.
The carrier should not have to enact an exclusion where the absence of that exclusion would allow them to provide coverage that would offend the public policy of the Commonwealth. That is the core of it, that even if you were intending to provide coverage for this activity, it offends our morals, our welfare.
Do you think the carrier that wrote the umbrella policy just had a more thorough underwriting process? Or did your client just want the premium so much that they didn't put the exclusion in, thinking that the hotel would just shop the business somewhere else? Which do you think it was?
Well, I can't I can't speak to underwriting intent.
You weren't unaware. Your client was not unaware that the umbrella carrier had this exclusion, right? I mean, they have put this into their policy.
I highly doubt that the primary had any awareness of what the excess carrier was underwriting, and even if it did, I don't know that would factor into the decision.
It would have made all the difference in this case, wouldn't it? This case wouldn't be here, right? If you we could draft exclusions to try to envision every scenario that would happen, but I can guarantee you there will be arguments.
Well, yeah, but
nonetheless.
How would that work? I don't want to belabor this, but let's say we weren't arguing under the public policy, and let's say we were sitting in the shoes of Judge Kenney, and you were arguing criminal acts exclusion. It would be done based on the allegations. Would Judge Kenny simply have to say, is there anything in the allegations that could be charged criminally upon which they might get convicted, and therefore the criminal acts exclusion applies? How would it apply in practice here?
I don't think the district court is in the position of deciding could it be prosecuted criminally.
So what's
The
the
district
question?
court is
What's the
deciding in their own right whether these facts
fall within the criminal acts exclusion?
fall within the criminal acts exclusion. They're going to make that determination, and that determination then is subject to review.
Seems
by
like a
the
more
appellate court.
straightforward. Seems like a more straightforward way of addressing this than a Third Circuit certification to the Pennsylvania Supreme Court.
And counsel,
No, I can't unravel that. So.
counsel, even after Greenfield, we've seen policies on numerous occasions that have a controlled substance exclusion, despite Greenfield, because it makes business sense to contain your exposure.
I can't quarrel with you. I mean, carriers will often, fine-tune policies, right, to insert exclusions. But I think that sort of strays from really, I think, the core question that's being certified. I don't think the issue here is, oh, well, could the insurers have done a better job, right, at writing the insurance policy? And
These are the facts that were presented. Right.
Ultimately, I think that's a factor. Once again, I keep coming back to the same issue for the federal courts to make those determinations. This is a really strict, but this issue is there a public policy right underneath the, as to be discerned from the statute, and then what is the required mens rea? So I appreciate these questions. They're good questions, but ultimately I think that's for really what the trier of fact, in this case the district court, has to wrestle with.
Okay, Mr. Sulzer, we get it. We understand your argument. Is there anything you'd like to say in conclusion?
Well, since I sort of strayed from my my remarks that I had
We
planned.
led you astray. We led you astray.
Well, I would just simply conclude to say that, and perhaps this is even recognized by my esteemed colleague, we all recognize that commercial sex trafficking is an epidemic in the state. It impacts the public welfare and safety of our citizenry. The legislature has enacted laws over several years in an effort to eradicate this horrific crime. I think it stands on its own, akin to the heroin problem that we have recognized by Justice Newman, that every case has to be viewed on its merits, and so this calls for a determination that our public policy, as reflected in the human trafficking law, may abrogate the duty to defend or indemnify, because if we find otherwise, and if hotels can essentially pass the buck to the insurance company for their culpability, we will have undercut the efforts of the legislature in their effort to eliminate sex trafficking in Pennsylvania.
Okay.
We would ask that you answer both certified questions in the affirmative, and I thank you for such a vigorous oral argument.
Thank you, Mr. Sulzer. Mr. Ellison.
Yes.
Enjoy yourself?
Excellent arguments by both sides. Thank you so much. Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus William Hitchner, representing Mr. Hitchner, Mr. William Hitchner, representing the Commonwealth, Ms. Rachel Kennedy.
Natural.
In this case, appellant pled guilty to driving under the influence and was sentenced to 1 to 2 years of incarceration, followed by 3 years of probation. Following a series of alleged technical probation violations, the issuance of bench warrants, the inability to find or apprehend appellant, and appellant being charged with additional crimes, a probation revocation hearing was held. At the hearing, the Commonwealth presented evidence of probation violations, new crimes, and appellant's absconding that occurred both before and after appellant's maximum probation date, and the trial court considered all these events in finding he violated his probation. We granted aliquotter to determine whether probation may be revoked only for violations that occurred prior to the expiration of the originally imposed term of probation, or whether the trial court may in effect extend the probationary term during periods during which a defendant absconds from supervision. Please proceed.
Good morning, Madam Chief Justice, Honorable Justices, excuse me, of the Pennsylvania Supreme Court. My name is, William Wismer. My Supreme Court number is 39220, and I represent the appellant, William Hitchner. In Commonwealth versus Rosario, in 2023 at 294A 3rd 338, this court ruled that sections 9754 and 9771 of the Judiciary Act, Title 42, prohibit the revocation of a term of probation before it starts. In other words, these two statutes prohibit the lengthening of a specified term of probation at the front end. Appellant William Hitchner contends that those same statutes prohibit the revocation of a term of probation imposed by the court that has expired. In other words, those two statutes prohibit the revocation of probation by lengthening it at the back end. The two statutes at issue here are sections 9754 and 9771 of Title 40.
Excuse me, counsel, but before we get there, I just need to clarify something because it's going to put everything else into context for me anyway. I understand the certified question we took, and I think we may have put the rabbit in the hat, but I just want to be clear on something, and maybe you and the Commonwealth can clarify this. Ultimately, the Gagnon hearing that we're talking about occurred on November 17, 2021, and was continued until April 26, 2022. Is that correct?
Yes and no, sir. The actual Gagnon hearing, Gagnon 2 hearing was the November 2021 date.
So at that hearing,
April hearing.
the only person that testified was the Delaware County Probation Officer, Deborah Lombardo, right?
That would be correct, sir.
And just so I'm clear from reading of the record, she didn't testify that anything the defendant did or did not do while on probation during before the term's natural expiration on July 19, 2018. Her entire testimony related to the defendant's absconding and failure to appear, which occurred on the record in 2019. Is that correct?
That's correct.
So how do we violate somebody's probation for conduct that occurred after the natural expiration of the date?
My appellant's position is that the court can't do that.
Isn't this a sufficiency question as opposed to whether or not there's an equitable tolling?
Well, no, it's not a sufficiency question. I don't think we challenge whether or not there was sufficient evidence to establish a violation.
Well, if I'm a trial judge at a Gagnon hearing and a probation officer comes up in front of me and the defendant's probation expires in July 2018, and the probation officer keeps testifying about a failed drug test that occurred in 2019, again, aren't I putting the rabbit in the hat? Because the probation, by its own terms, expired on July 18th, 2018, or July 19th. Why do I care what happened in 2019?
Judge Pagano agrees. Judge Pagano in the Delaware County Court of Common Pleas agreed. In fact, the judge went so far as to find that.
Well, I know he agreed, but the Superior Court basically reversed him and said
The
was
Superior
allowable.
Court did.
I mean, before we get to the certified question, my question is, this is to my way of thinking, as a former trial judge, this appears to be an illegal sentence. If it's an illegal sentence, we have to correct that illegal sentence before we can even get to the certified question. You can't sentence somebody for a violation that occurred after the expiration of their probation, right? It's fundamental.
That's our position, yes. And I think that's the overriding issue here, is not whether or not sufficient evidence was presented, but whether or not you can even violate the defendant for transgressions that occurred after
I think we're saying the same thing.
Yeah, counsel, the question is, I think, answers itself. I don't think anybody's arguing, I don't think the prosecutor or our probation and parole is arguing that you can charge someone with violating a term of probation after the probation has expired. I mean, that seems to be, have you found somebody that disagrees with you on that?
To answer your question, it seems that it seems to have been assumed that the probation continues.
So that's the point. So really, that's the issue. The legal question: can a term of probation? Can someone be charged with violating a term of probation when they aren't on probation? I don't think anybody would agree that they could. The question is, was it proven? And this, I think, goes to Justice McCaffrey's point. Was there proof at the Gagnon 2 hearing that at the time that he had absconded, that he wasn't under supervision during a period that he was supposed to be under supervision? Because you would have to agree that if you're not under supervision, that the period of time you are absconded, you are not under supervision.
I would agree.
Okay. So I think Justice McCaffrey's saying the question is not whether they can do what you're asking. They clearly can. The question is it what they did here? Did they extend a period of parole for a probation violation that occurred after the term was over? Their argument is the term wasn't over because you were absconded. You weren't under supervision. So the question is, at the Gagnon 2 hearing...
That's as I understand it.
Okay. So at the Gagnon 2 hearing, was there evidence that your client, during a period when he was supposed to be under supervision, had absconded?
Sir, are you asking if there were the original? I'll see. I'm trying to clarify your question. The original run date of the probation, 3 years from when it was imposed, was July 19th, 2018. There was no evidence at the Gag 2 that of any transgressions, of any violations before that date.
So there was no evidence that he had absconded prior to that date?
That's correct.
And what the Superior Court did, I think, if I understand it correctly, is they concluded that your client absconded just because he wasn't under supervision, as opposed to making the legal determination of whether or not that was actually absconding, because you need to prove a violation in order to come to the conclusion that he absconded, correct?
Yeah.
And that's what happened here.
I agree.
They just looked at the fact that he wasn't under supervision and missed the whole point that unless he was found in violation, he was free not to be under supervision.
Well, what about the bench warrant that was issued in February 1st of 2018, about 6 months before his probationary term ended?
That resulted in, as I understand, he was, the defendant, the appellant was arrested on that warrant after the expiration of the original probationary term.
Well, the probationary term ended in July of 2018, and the bench warrant was issued in February.
That would be correct. That would be correct. There was a
Is that
gap.
bench warrant reflected in the record or the docket? I had problems, because that's exactly my concern.
Yeah.
Where, in this record, is the initial bench warrant docketed?
Sir, Justice Doherty, I haven't looked at the docket, but it's a matter of record in the proceedings from the original Gagnon 2 hearing in, I believe, November of 2019, that there was a warrant issued because of information received from the state of Delaware. And
that information was received during the pendency of his probation?
That's correct. That's correct. And the Gagnon 2 hearing took place, and the first Gagnon hearing took place after the original expiration of the probationary period, but dealt solely with allegations of violation that occurred during the original probationary period. Thus, the warrant was issued in February 2018 before, probation expired.
Okay.
However, that initial Gagnon hearing dealt solely with allegations presented by the state of Delaware. The probation had been transferred down there. The defendant the appellant was found in violation. He was resentenced, he appealed, and the Superior Court sent that back, saying the grounds for the violation were inadmissible hearsay. You got to give him a new Gag 2 hearing, and that's when all of this started. By then, his supervision period had obviously expired, and that's when all this started.
Thank you.
So until he was apprehended and what was happening, at least we can glean from the record, between the period of the end, what you say is the end of his original probationary term, and the period he was apprehended?
Well, which time? I mean, he was apprehended he was apprehended, jailed, released quite a few times, because he would be confined, he'd undergo a Gagnon 1 hearing.
I'm talking about after his, when do you believe his probation ended?
July 19th, 2018.
July 2018. So was he, prior to that, during the period of his supervision, had he absconded?
He did.
You're not disputing that?
No, I'm not, because he ultimately faced a Gagnon 2 hearing.
Right, so how can you be under supervision if you've absconded?
You're not.
So there's a period of time that he had absconded that should not count toward his original period.
No, I'm not saying it shouldn't count.
Well, why shouldn't it?
I agree he absconded. I'm not
Why
saying
should it, if you're not under supervision because you absconded, how are you under probationary supervision for that period of time?
Well, you're not.
But isn't it a fact that you can't abscond unless you violated your probation?
Well, the absconding itself is a violation.
Okay, so could he have incurred the result here just by the absconding, or did they first have to prove the initial violation?
No, I believe that the absconding is my understanding anyway, is the absconding itself is a violation. Absconding to me means you were supposed to report, you didn't. We were supposed to have an approved address. We didn't. We can't find you. We've left messages, cards in your door. You're not around.
So based upon-
Counsel, during his period of probation, your client failed to appear during this period of probation to the probation officer several times, such that the probation officer requested a bench warrant for him as a violation of the transferred probation. Yeah, am I correct?
Prior to the scheduled expiration of probation in July of 2018,
Correct.
when he was sentenced, the supervision was transferred to the state of Delaware. The state of Delaware notified, prior to the expiration of the probationary term, the state of Delaware notified Delaware County that he's in violation, we're sending it back under the interstate compact. That's all they can do. They don't have violation proceedings down there. They send it back to Delaware County to deal with it. When Delaware County got it back, Delaware County requested a warrant.
That was February 1st, 2018.
February 1st, 2018.
They request a warrant, so why shouldn't we just apply in response to Justice Dougherty's question, the doctrine of equitable tolling, and extend it off for another 6 months is the question.
I'm sorry, could you
Sure.
repeat that, sir?
February 1st, 2018, you just said they issued a bench warrant because he failed to appear, which we all know is a violation of your probation, correct?
Yes, sir.
He could have been violated based upon that at simple failure to appear, sentenced to 3 to 6 months when he's picked up. You agree with that?
Yes.
So the probation expires July. The bench warrant's issued February 1st. He doesn't get picked up again until September, right?
Correct.
All right, so why don't we just apply the doctrine of equitable tolling for the extra 6 or 7 months?
Well, that's the whole point. I don't believe equitable tolling applies here because it's not permitted by the probation statute. It's not in the statute. 9754 requires a fixed term of supervision.
Correct.
That's what this court ruled in Rosario. That means a fixed term, beginning, end. The 9754 does not allow, does not mention tolling. It doesn't mention circumstances under which tolling might take place. It doesn't give any other guidance on what is absconding.
So
It's not in there.
is it your position that a defendant sentenced to probation, the defendant fails to appear, never shows up, and the bench warrant's issued, but it doesn't count, or we're not to take that into consideration?
No.
Based upon the fact that the statute doesn't indicate it? Is that what you're sharing with?
No. What I'm saying is, if a term of probation is, if the appellant is sentenced to a term of probation and absconds a week later, and there's a warrant issued, he's violated his probation.
And that's what we have here, correct?
That's correct.
Okay.
Well, no. Yeah,
that's what we
this case, Mr. Justice Doherty, is an anomaly because he violated early on, and the Commonwealth brought that violation into court within the period of time that he was on probation. The court found that he was in violation, but based on hearsay, and it was sent back. But by the time it got back from Superior Court, the probationary term had expired, and for whatever reason, I think I know why, but I'm not going to speculate, but for whatever reason, at that second Gagnon 2 hearing in 2021, the Commonwealth abandoned, just gave up on any allegations of a violation prior to the expiration, the original expiration.
The original abscondment. You're saying they gave up on the original abscondment.
Yes.
Well, they didn't give up on it, they just didn't present any evidence. They instead, that's what I was trying to get at the beginning of my remarks. What happened in 2021 was that they testified to things that happened in 2019, which was after the natural expiration.
correct.
They didn't abandon anything, they just didn't put anything in about the pre-natural expiration violation. In other words, they didn't put the evidence in that he absconded while he was on probation. Instead, they talked about the failed drug test and the bench warrant that was issued in 2019, which was after the expiration of the probation.
That's correct.
Well, where was he while the Superior Court appeal was going?
There was 2 Superior Court opinions.
No, I
Before
don't.
the Gagnon 2 hearing, where was he? Was he under supervision at any point?
Well, he was, the original Gagnon 2 was in 2019, after he had been apprehended.
I mean, he didn't even show up. He didn't even show up for the
Well,
Gagnon.
at times he did. I mean, he was in and out during that.
Was he under supervision? So supervision end according to you on July what?
19th.
July 19th. What did he show up in June of 2019?
I'd have to. I don't have all.
Did he show up in May?
I know that he was supposed to. He was in and out. There were times he would get picked up.
No, but was he showing up for his check-ins with
He
his
was
probation?
not. He was.
So
not.
he's absconded.
Well, he was invited. Okay, yeah, he absconded. He was in violation of probation.
He wasn't under
Not only didn't show, he gave hot urines.
He wasn't under supervision.
That's my contention.
Right.
Supervision ended in 2018.
No, but I'm talking about before 2019. Was he under supervision?
Well,
Before July 2019, was he under supervision or had he absconded? You can't be both.
no, I mean, that's the whole point. The probation didn't survive July 2018.
I understand. I'm saying
That's my
prior
point.
to. I'm saying prior to July, for all the periods from July prior, how long was his probation? 3 years?
3 years.
Was he under supervision during that 3-year period?
Prior to July 2018?
Yeah.
Well, yes, until it expired.
You said he absconded. How can you be absconded and under supervision at the same time?
Well, all right, I'm sorry, sir, I'm not understanding
Let
the
me try to
question.
explain. He's on probation. Probation expires July of 2018. In February 2018, there's a bench warrant issued because he fails to follow conditions of probation.
That's correct.
He's not arrested until January of 2019.
That's correct.
At that point, he was arrested based upon the bench warrant
2018.
2018.
Correct.
So it's your position that as long as an individual bench warrants longer than the term of their probation, they get a free pass.
No.
Then tell me,
No.
what
No.
Justice Brobson's trying to ask you, from February 2018 till he was arrested in 19,
Right.
was he under supervision or did he
He
abscond?
was under supervision until July of 2018. He absconded before July of 2018. He violated his probation.
Counsel,
In
hold on.
July, or in February
And
of
when he was
18.
picked up in 20, and when he was picked up, he was subject to a Gagnon 2 hearing for the violations that occurred prior to July 2018. That's what the Commonwealth attempted to prove at the first Gagnon 2 hearing.
Counsel, I think that the problem is that we're using terms interchangeably. Justice Brobson and Justice Doherty are asking you a simple question. He's on bench warrant status before the expiration of his natural term. He was on probation, but he wasn't being supervised.
That is correct.
That was the distinction.
And the
Thank you.
the statute says, in imposing an order of probation, the court shall specify at the time of sentencing the length of any term during which the defendant is to be supervised.
Correct.
So,
what it says.
so from the date of the bench warrant to the end of his original probation term, was he being supervised? Because that's what's, well, okay, then how could it count toward his period of probation if he wasn't being supervised?
Because he was given a 3-year term that expired after.
A 3-year term under which he's supposed to be supervised. He absconds, so he's not supervised.
I mean, that's the whole issue here, is whether or not.
My concern is, tell me how if we adopt your view of this, we don't encourage people on probation to go into the wind until the end of their termination to avoid being arrested on a bench warrant and simply come back in after the fact and say, hey, I don't have to come to a Gagnon. You didn't arrest me. You never proved I absconded. I escaped. I avoided.
Mr. Justice Brobson, my point is not that he is beyond reach. If he is violated prior to the expiration of the probationary term, he is not beyond the reach of the courts.
You can have the hearing after the term.
He can have a violation hearing after the term expires.
So this goes to Justice McCaffrey's point at the beginning. Your issue is not that you're not claiming that a person who absconds is under supervision. You're claiming they simply didn't prove at the Gagnon 2 hearing that he had absconded.
Correct.
That's your point. I mean, it's an evidentiary issue. It's not a legal question. It's an evidentiary issue. Did they prove that he had absconded prior to the termination of his original term? And you're saying they didn't because they abandoned it.
That's correct.
Okay.
That's correct.
And no one asked the question, why are you here in January? When he was recovered. He's now brought in custody, I assume, in Delco in January of 2019.
Right.
What's absent, or at least I could not find from the record, was there any indication that he was standing before a Delco judge because he had been picked up on a bench warrant for absconding probation?
I don't.
Do you know or you don't know?
Finish, please.
I'm asking, that's the question.
No,
Because
no,
then
no,
there
what-
would be evidence on the record that he absconded, which would defeat your argument that it was not introduced. So that what I'm trying to get to me, the pivotal question is when he stood before a Delaware County judge, did anybody say, where'd you come from? We transferred this to to Delaware. And someone would have to say, yes, Your Honor, he violated or he absconded from Delaware State and they violated him and he's before us on a bench warrant. You would have to lift the bench warrant. The Delaware County judge would have to lift the bench warrant, which means if that's so, then it's part of the record that there was evidence that he absconded.
Happened at a Gagnon 1 hearing.
Still a hearing in front of a judge, correct?
No, it's a hearing in front of a hearing master, and I don't believe it was recorded, and I didn't represent him through these
Was
proceedings.
the bench warrant withdrawn at the hearing?
At the Gagnon 1 hearing, he was released.
But therefore, the bench warrant had to be withdrawn, which means it has to be part of the record that there was a bench warrant that was issued during his term of probation.
I would agree.
Yeah, that was, I can I know, but I can clarify what your date was. The first Gagnon, Justice Doherty, was January 23rd, 2019. Defendant picked up a new arrest. He was arrested. At that point, they established probable cause that he had failed to appear. The defendant was released. The bench warrant was withdrawn. It was ultimately continued because of the Superior Court appeal that went up. The Gagnon hearing that we're limited to today, I believe anyway, was what I just asked at the beginning, because I wanted to be clear on that, which was November 17, 2021, which was continued to April 26, 2022, where the testimony that resulted him in being sentenced was based upon probation officer Deborah Lamberto of Delaware County's testimony, which had to do with what happened in 2019 and 2020. That's what happened. So at the Gagnon 1 hearing, they lifted the bench warrant, continued it for the Gagnon 2 hearing. Meanwhile, there was a Superior Court case that went all the way up. Superior Court kicked the case back. He had a new arrest at that point. That's why I asked the question at the outset, because I thought I was going to streamline this process, and I think we're playing who's on third now.
Well, I think he got a new arrest after he'd been
He
incarcerated.
did.
After his incarceration.
Correct. And then Officer Lamberto testified to that new arrest, and failed to testify that he failed to show up for drug tests, and also failed to show up on the extension of the probation. But there was no testimony in the record, which is what I was trying to establish, that he had failed to appear during the term of his original 3-year probation. That's it. So this was, and as I keep saying, this was an illegal sentence because you can't violate somebody for conduct that occurred after the natural expiration. Everybody here is focused on the bench warrant in the record that occurred during January of 2018 or February of 2018. Do you understand that, what's going on?
I think I got it. It seems to me that what it ultimately boiled down to was a subsequently scheduled Gagnon 2 hearing that focused solely on what happened after the original expiration of probation. And that's the problem.
That's
Yeah,
exactly
you
what I
can't-
just said.
yeah,
It's right.
Right, the Commonwealth can't pursue alleged violations that occurred after the probationary term expired. Right?
That's our position.
Just can I just clarify something? Because I've done thousands of these. In response to what Justice Brobson said, if a probation officer had walked in the door and said, Your Honor, a bench warrant was issued for the defendant. Here's the certified bench warrant of February 21st, 2018. Delaware sent it back to us. The defendant failed to appear, failed to report. At that point, they could have violated him because there was evidence on the record that he had failed to, that a bench warrant was issued and he had failed to report during the term of his probation. You wouldn't be saying, Judge, that's not a violation, would you?
If it happened.
The answer is no, I would not be saying that, Your Honor.
If it happened prior to the
If
expiration.
it happened prior to the expiration, and we know that. So if Officer Lamberto had walked in the door, even in 2021, and said, here's the bench warrant that was issued on February 1st, 2018, 6 months before the natural expiration, the defendant failed to appear. That's a violation, right?
That is correct.
So in answer to Justice Brobson's question, he's not within the reach of the court for a violation that occurred during the course of his probation, right? Yes?
He's not, you're asking, is he within the reach of the court?
I'm asking a simple question. This is really simple. I don't mean to be frustrated, but if Officer Lamberto had produced proof at a hearing that he had failed to appear during the course of his probation, that's a violation, correct?
Yes.
Thank you. Let's leave it at that.
I'm sorry. Mr. Justice Brobson, I don't believe that a probationer who absconds and then is arrested after the expiration of the original probationary period is getting away with anything. Once he's arrested, he's going to be subject to violation.
Well, that's
Violation hearing can happen.
right, but the point here, which I think Justice McCaffrey has driven home with you, is what you're saying didn't happen here is he was arrested on the bench warrant, no doubt, but when it came to actually the Gagnon 2 hearing, the Commonwealth, for some reason, I guess we'll hear soon, didn't present any evidence of the original absconding from Delaware.
That's correct?
That's what the case is about. It's not a case about whether the Commonwealth can extend a probationary period that's expired. Clearly, they can't. The question is, was there a parole violation because of abscondment? And your point is very simple. They didn't prove it.
That's correct.
Okay.
Okay, Mr. Whistler, I think we have it.
Yep.
Thank you very much. Let's hear from the Commonwealth. Let's hear from the Commonwealth. Ms. Kemi?
Good morning, Chief Justice Todd, members of the bench. My name is Rachel Kemi. I'm here on behalf of the Commonwealth of Pennsylvania, Delaware County District Attorney's Office representing the appellee. I'm going to jump right into Justice Brobson. You had started with a question about whether or not the Commonwealth was going to be here arguing that we could extend someone's probation when we can't. But that's not my argument. My argument here is that the date that everyone keeps mentioning, this magical run date of January 18th, 2018, we don't contest that that was the date. Should defendant have abided by the terms of his probation and remained under supervision, it absolutely would have expired on that date. But we keep using this date as though it's the end-all be-all. It's not. The sentence is the end-all be-all, and that was that the defendant served 3 years of probation. Probation is a supervisory term. It's a supervisory capacity. You have to be being supervised for that term to count. The mechanical run date of this July 18th, 2018, is the date that probation puts together. Should you abide by all of your rules, this is when you'll be done. What happened here was that the defendant was not on supervision for almost a year. Okay? When he was picked up on that warrant and did come before a Gagnon 1 master for determination of whether there was enough information to say that he violated.
Probable cause.
They did, right? Probable cause to violate it. They found that. He was released. Okay, from there,
They found probable cause, then he was released. And a magistrate can't extend the terms of probation. That's got to be a judge.
Correct.
Okay.
Correct, Justice McCaffrey, yes.
So you're going to argue equitable tolling, right?
Yes.
Okay.
Essentially,
So let me just ask the question I asked your opposing counsel at the outset. We are here today to talk about a sentence that was imposed on April 26, 2022, for a Gagnon 2 hearing that started on November 17, 2021.
Yes.
At that hearing, did Officer Deborah Lamberto, the Delaware County probation officer, testify or present any evidence whatsoever that he had absconded and had failed to appear during the term of his probation, before it naturally expired, before we even get to the equitable tolling? Because to my way of thinking, if there's an illegal sentence, we have an obligation to fix that illegal sentence before we can even get to the equitable tolling question, right?
Absolutely.
So did Deborah Lamberto testify or put any evidence in the record at that hearing on the 21st, November 17, 2021, or April 26, 2022, that the defendant had absconded, failed to appear during the course of his natural 3-year probationary term?
My reading of Deborah's testimony was that it was mentioned. Do we move forward on that allegation? No.
Then how do you violate him?
Because
She
he was-
testified about the failed drug test and that he failed to appear after the fact, which you can't violate somebody for. My question's an evidentiary one. You can't sentence somebody to you can't find a violation unless you found that they violated while they were on probation, right?
Yes.
So was there any testimony that he violated while on probation, or was that testimony about stuff that occurred in 2019, 2020, and 2021?
Our argument to that would be that he was, all of those things, those 19, 20, 21, he was still on probation for. Our argument is that it did not.
I thought you just conceded to Justice McCaffrey, or to all of us, that the statute doesn't allow you to extend a term of probation.
It doesn't.
You seem to want to have it both ways. Like he absconds, so he's not under supervision, and yet his violations during that time can be used. I'm not sure how you can have it both ways.
Let me clarify, Justice Wecht. When we say that the defendant was on probation, we don't mean to say that we're just going to keep extending and extending. The defendant still owed that time. That's our argument. Whether that was the 6 months or applied to some other defendant who absconded for 2, 3, 10 years, when you're picked back up, we're not asking you to serve more than you agreed. We're asking you to just finish out the term.
Commonwealth, the question is, was that evidence introduced and part of the record? What Justice McCaffrey was initially indicating was all the information that led to the probable cause for the violation post-dated the expiration of his probation. Was there any evidence that there had been a bench warrant during the pendency of his probation, that he absconded in the state of Delaware? That's what he's indicating, that the record is absent. And I'm indicating, I'm questioning, I couldn't find it in the record. I was asking if you know, was that introduced as part of the Commonwealth?
I understand your question, Justice Doherty, and the answer to that is no. I do not believe that at that particular hearing, evidence or testimony was put on about the allegations that originally rose from Delaware. I do not. I don't see it in the record either.
I'm sorry, just to follow up on Justice Dougherty's question. So then, what is the legal basis that empowers us to validate you seeking a revocation based on new crimes he committed while he's an absconder? I don't see the authority for that.
Well, it's not necessarily for new crimes that he committed while he was absconding, because some of these crimes also were, once he was picked up on a warrant, he gets the new case in jail. He's not necessarily absconding then. My argument is that everything from the time that defendant agreed to serve this 3-year term till we get to this hearing, final gag 9 years and years later, is that all of that time he was on probation.
But this is not Rule 600. I mean, there's no authority in statute or rule for this kind of equitable extension that you're seeking. Where does that authority come from in the statute?
Well, I agree with you that it's not specifically written out in the statute, but 9725 says that the judge is supposed to prescribe a term of probation.
Well, it talks about the conditions. The court can mess with the conditions, right? But it can't extend this. This is a sentence, part of the sentence.
Yes, our argument is that it wasn't necessarily, we're using the word extended maybe 2 different ways.
Be careful.
And that's maybe what is, I'm confusing for the court. Extending it, what I mean by that is we're just asking him to serve the term that he agreed to. I don't think we extended it past 3 years.
Well, this could, just one more thing on this, if I may.
Oh, sure.
It seems like the logical extent of your argument, counsel, would be that if we kept doing this in a scenario of, absconding, to use your term, you could easily get to a point where you'd be beyond the statutory maximum. And that would be nonsensical, wouldn't it?
Yes.
So what's the difference between a hypothetical like that and your situation?
Well, the difference, and I hate to beat a dead horse, but this really is where at least my mind stops with this, or I can't get past, is that if we use this July date, this July 2018, and we say, well, probation ended then, well, then he's rewarded for absconding for that year that he wasn't.
You still violate him for things he did during the term, right?
Yes.
But that's what didn't happen here. Nobody proved that there was the bench warrant outstanding and then he had to be arrested during the period of probation. It would have been easy. It would have been easy for the Commonwealth to prove that.
That's it in a nutshell. It's the Commonwealth's burden to prove that there had been an open bench warrant. And the record is conspicuously absent that such existed. The record only indicates of all the potential violations that occurred after the expiration. Had someone introduced that bench warrant, we wouldn't be here.
Well, actually, they couldn't introduce the bench warrant, could they? Because the bench warrant was declared by the Superior Court to be void ab initio. That's the key I'd forgotten in this particular case. The Commonwealth relied originally on the bench warrant from Delaware State being issued in Delaware County. That was appealed to the Superior Court. The Superior Court declared that bench warrant void ab initio. And now I'm reading, if you just bear with me for a second, because it just ticked my memory. The September 13, 2022 opinion from Judge Pagano. This court then held a Gagnon 2 hearing on November 17, 2021, wherein the Commonwealth, as his words, completely abandoned reliance upon any alleged Delaware State violations and went to great lengths in order to exclude any information regarding violations that occurred prior to July 19, 2018 maximum date. Rather, The Commonwealth offered allegations of violations that occurred on or after March 22nd, 2019, which was 8 months and 4 days after the scheduled supervision maximum date. That was the basis of Judge Pagano's decision. Is there anything wrong about that? Because I asked a question at the outset about the evidence. That evidence came right from the record and was also contained in Judge Pagano's 1925 opinion, that the Commonwealth didn't produce any evidence of a violation that occurred before the natural expiration, and the basis of the equitable tolling argument was the bench warrant that was declared void ab initio by the Superior Court.
I see where your argument goes, Justice McCaffrey. I can't tell this court why the Commonwealth didn't proceed on those Delaware charges. I don't know. My guess is that because we had all of these other violations, we decided to move forward with that. Do I think that there is a bit of a difference here had we argued all of the violations, including that one? Yes, it's entirely possible. But I do think that that doesn't necessarily negate the fact, or at least what I would ask or urge the court to take into consideration, that if we let that go, the end result of that is that defendant never really served his 3 years.
But that's
the
an argument for
Commonwealth's
the
problem.
General Assembly. They obviously know how to put tolling provisions in statutes. I mean, they've done it, as you know, counsel points out, they did it in 54. I mean, it's an argument you're making for policy that belongs in the legislature's bailiwick, not in ours. We don't have this power to do that. Notwithstanding what Superior Court did in Ortega, we don't have the authority to sort of invent tolling doctrines, do we, in this criminal law context?
No, I see where you're going with that, Justice Wecht. And I would say, though, and again, it's, as you mentioned, Ortega is by no means controlling on this court. It is Superior Court opinion. But Ortega, and actually recently in 2024, and I'm going to get the name wrong, Grygek, the Superior Court again mentions that absconders can't be rewarded, the time tolls. So I would throw it out there as instructive or a good argument to follow, is that our lower courts have, in fact, sort of addressed the issue, and I would just urge that the court
I don't know why
take it into
equitable tolling is the answer. I mean, you had said something earlier that I thought was pretty interesting. You had something about he owed the time.
He did.
Right. What evidence did you produce at the Gagnon 2 hearing that he owed the time? That he hadn't fulfilled his 3 years of probation?
Well, I would argue it was Justice Lamberto's testimony to the court.
Whose?
Justice Lamberto, I've just elevated her to.
I'm sure she's excited.
Yes, she's excited. I will tell her that later.
Yeah.
The parole officer. Again, I can't tell you that she handed up this warrant and.
Well, you can tell us what she did. Did she prove?
She didn't.
Did she? Well, you can tell us what she did. Counsel, hold on for a second. Did she prove he owed time?
My argument would be yes.
How?
With her testimony to the court.
Which was?
Well, she explained to the court how everything got to where we got to. I mean, she did talk about what happened in Delaware and that supervision was transferred to Delaware County and that they'd issued the bench warrant, they couldn't find him. She did talk about all of that.
So she testified that he was absconded for a period of time from his term of probation.
Yes, and I use the word absconded.
Well, then why did Judge Pagano say that you abandoned it?
I don't know. I don't know, and we didn't agree with Judge Pagano even when he then wrote his opinion. He originally found her in violation, wrote his 1925A opinion, and changed his mind.
So you're telling us today, and I'm sure Justice McCaffrey has looked at the record very carefully.
Yes.
You're saying there is evidence of his violation of the terms of his probation in Delaware.
Yes. Arguably, I would say yes.
What do you mean, arguably? There is evidence or there isn't evidence? Is there evidence that he violated the terms of a probation in Delaware?
Okay, I do see what you're saying, Justice Robson. Her testimony did not talk about the underlying violations in Delaware.
Okay.
What she did talk about was that they had received information that he was allegedly violating in Delaware.
Right.
They asked Delaware County to issue the warrant.
Right.
Delaware County did.
Right.
We picked him up because we couldn't find him for a year and some time.
Right.
You're
saying that's proof that he owed time?
Yes, that time that he was absconded, yes. I would say that that's proof that he owed time, yes.
So he wasn't So under all that time that you want carved out, he wasn't under supervision?
Yes.
Right, is that right? He was not under supervision for purposes of your legal analysis?
Yes, Justice Buck. For purposes of our analysis, the only
So
time that
any of
we're
those- any criminal acts he committed during that period, then he would not be susceptible to revocation based on those, right? He couldn't be since you weren't supervising him.
any acts that he, I'm sorry, just so
So it
that I
seemed like
understand.
you'd like to have it both ways there. Either he was under probation supervision or not.
Well, he wasn't under supervision because he wasn't doing the things that one is supposed to do when under supervision.
Well, either he was or he wasn't. So, because if he wasn't, then the provisions are inoperative.
I guess,
Can't be-
yeah,
can't be-
I see.
You can't be under supervision for some purposes and not under it for others.
Well, I would argue he was supposed to be under supervision during that time.
Did any, I mean, I'm going to take one more shot at this because, I never did this before. Did some judge somewhere adjudicate him as an absconder from his original probationary term?
Like, let me just make sure I have the
Oh my gosh, I
was
thought
there
it
a
was pretty
hearing to
clear.
determine, well, hold on, was there a hearing to?
No, did a judge,
Okay, yes.
did any court adjudicate him to have been an absconder during his 3-year period running from the date it began to this July magical date? Has anybody ever adjudicated him to be an absconder during that period?
I would argue the only time that would
I
have,
don't want you to argue. I just want you to tell me. I want you to tell me if they did. Can you point me to a judicial order or an opinion or something where some court adjudicated him to have absconded during that 3-year, what you call the magical period?
no, not necessarily.
Okay.
No. And if there are, Madam Chief Justice, I would be happy to answer anyone's questions. If not, I will sum up. Sure. The Commonwealth's argument is not to say that we're asking anyone to do anything that they didn't already agree to. The defendant agreed to serve 3 years of probation. My argument is that all 3 years of that have to be under the probationary supervision. I understand appellant's argument. I just caution that I think in order to get to that, what it is saying is that there is some merit to absconding and not finishing out your term just because of this mechanical.
Can I just respond to that real quickly? Because you said that before.
Okay.
Maybe the lesson is not on us. Maybe the lesson is on the Commonwealth. And that if you want to make the argument that a probationer was not under supervision during a period of time and you don't want that time to count, you have to prove that, in fact, they were not under supervision during the time that you're claiming to carve out. Maybe that's the lesson, not what we do.
And that is certainly within this court's purview to decide, yes. So, but I respectfully would just ask that you affirm the lower court's decision. And on that, I will rest. And congratulations to everyone who was retained, too.
Thank you.
Thank you both.
Peter Precht versus the Unemployment Compensation Board of Review. Representing Mr. Precht, Ms. Julia Simone Michel. Representing the board, Mr. Keanu Peters.
Good morning. It's still morning. In this appeal by allowance, a claimant lost his employment with an optical company and thereafter created an online optical consultation business and designed a website, but did not perform any services for compensation. When the claimant later sought unemployment compensation benefits, he was deemed ineligible on the grounds that he had taken positive steps toward establishing his own business, rendering him self-employed and thus ineligible for benefits under the Unemployment Compensation Act. On appeal, based on this court's 2020 decision in Lohman versus Unemployment Compensation Review Board, the claimant contended that the standard for determining whether a claimant is self-employed is not the positive steps test employed by the lower tribunals, but rather the test set forth in the Act in Section 4L2B, which specifies control and independence considerations for self-employment. The claimant argued that the statutory test was not satisfied as he had not performed any services for wages in connection to his consultation business. In a divided decision, the Commonwealth Court rejected the claimant's contention and upheld the positive steps standard. We granted allowance of appeal to determine the propriety of that court's ruling. Please proceed.
Good morning, Chief Justice, members of the court. Julia Simon Michelle from Philadelphia Legal Assistance on behalf of Appellant Peter Precht. And if you'll I apologize, I may need to take a few breaks. I was with 2 sick toddlers all week, and I'm starting to lose my voice a little bit.
Do you have a glass of water there?
I have a water bottle.
Okay.
We are here today to address whether the Commonwealth Court's judicially created positive steps test should survive in light of this court's recent precedent. Both appellants and the government now agree the answer to that question is no. In Lohman, this court held that the General Assembly had intended for the two-prong test from Section 4 to be the exclusive and definitive test for evaluating eligibility under Section 402H of the law. Lohman involved a worker for a third party, in that case, Uber. The court, because it was not before it, did not explicitly rule on whether the positive steps test could continue to be used as part of the Section 4 test in the standalone context. As the President Judge noted in her dissent below, the Commonwealth Court majority in essence took that judicial restraint as tacit approval of the positive steps test and continued to apply it in this case. We are now back before this court to squarely address the question of the positive steps test in the standalone context. The court should permanently abandon that test today for 3 reasons. First, the test directly conflicts with this court's interpretation of the independence prong, primarily that whether someone is customarily engaged, as this court interpreted in a special touch and in Lohman. Second, the positive steps test contravenes the plain language of Section 4, which requires an established business in the past tense, not simply a step towards establishing a business. And finally, the test undermines the remedial purpose of the unemployment compensation law by punishing claimants who try to explore a path to financial independence, and also causes differing treatment of claimants under the law.
Do you have to receive remuneration, or is it enough to just hold yourself out as performing services for remuneration?
It's not enough to hold yourself out as performing services for remuneration. The general idea here is that in addition to the two-prong analysis, there's a prerequisite in Section 4 that you must first have performed services for wages or remuneration. So you have to perform the services for that.
For remuneration. In this case, were there any wages or anything for remuneration?
No, he had no clients, performed absolutely no
So
services.
you never get to the two-prong analysis?
Yes, in this case, the argument would be you don't even go, you don't pass go and get to the two-prong test.
So, Counselor, can I ask a question about that? How do we square that, the wages definition with the reality of what the Act is supposed to do? In this particular case, you've got an optician
Yes.
who basically is collecting unemployment compensation. If I'm an optician and I go out and I'm collecting unemployment compensation and I form an LLC and I hire somebody else to perform the services for me, like in this case, I set up a website, I set up an LLC, they're performing the services, that person, my employee, is getting paid. If that person's getting paid and I'm making money,
That would count for the purpose. That would count because.
that's not a wage. That could be a return on an investment, it could be any number of things. A wage, by my way of thinking, and it's not really defined under the Act, would be something along the lines of a W-2 employee. If I'm the sole shareholder of a company and I'm getting return on my investment, through passive investments or through active investments, I'm still getting money. I mean, theoretically, I could be making 4, 5, 6, 7, 10 times the amount I made as wages in my prior employment. Wouldn't that defeat the entire purpose of the Unemployment Compensation Act?
Well, that's why in this case, when you're looking at remuneration, you're looking at a lot of the different definitions in Section 4, right? Which all point to, I think, a broader acceptance of what type of income counts here, right? And if you actually.
That's my question to you. Where do we draw that line?
In this point, I think a business that is actively performing services for pay, right? For any sort of pay or compensation.
That's not what the Act says, and that's not what you're advocating. You're saying that the employee, Mr. Precht, is not performing the services.
No, Your Honor, actually, that's not what we're saying. Because in this situation, what they're asking is whether he has an independently established business. It's whether that business has performed services.
So if the business is performing services, even though he's not receiving wages from that business?
Well, this business did not provide any services.
I'm just asking a hypothetical.
If the business had clients, had performed services, and had therefore received pay or any sort of compensation for those services, that would be enough to meet that prerequisite and then turn to the two-prong analysis. It wouldn't be enough to necessarily say that individual is self-employed, but it would certainly meet that initial prerequisite in this case. Now, for Mr. Precht, he did not do any of that. At most, he was developing a website. There were no clients, there were no services performed, and in a special touch, and then again in Lohman, this court made clear that in order to be customarily engaged in an independently established business, there must be someone who is actively holding themselves out as providing services or who is actually providing services. It's not about what someone could do. It is about the facts of what they have done. And in fact, in Lohman, this court said that an occasional offer of work, an acceptance of work is not enough. So certainly no offer of work and no provision of services can be enough under that reasoning, which is why not only Mr. Precht should be eligible, but also why the positive steps test can't continue. Because the entire premise of that test is that you can take steps towards establishing a business, but does not actually require, like this court has in its cases, the actual provision of services, that somebody is habitually providing services, which is how this court defined customarily engaged in its prior cases.
I think part of the confusion in this case is the income tax return that was filed or scheduled to it that indicated the payment of wages. We don't actually know what that is.
There is no evidence or testimony on the record that describes anything that happened in that Schedule C. What the claimant did testify to is that he was actively developing a website, and so it's...
So he could have paid someone to set up the website?
Yes.
Could have paid his wife to set up the website?
Yes. And it's not unusual for individuals to expend resources as part of this process. And that I know that concerned the Commonwealth Court below, right? And I understand that concern. But I would put forth to you that it's not unusual for jobless workers to spend resources on bettering themselves during a period of unemployment, right? Someone could spend that money on a training course. Someone could spend that amount of money on buying a better wardrobe. Someone could spend that amount of money to invest in a car.
Getting a real estate license.
Yes.
Or in anticipation of engaging in a business that never goes off the ground.
Yes, or in anticipation of making themselves a better candidate for a better job, right? And as the President Judge said below, from a policy perspective, isn't that what we want, right? Why are we punishing someone for spending their money on that as opposed to taking a vacation to Greece? And so while I understand the concerning aspect of the fact that somebody reported a loss, I don't think that takes this claimant, this jobless worker, out of the realm of being connected to the active labor market and being eligible for benefits that he qualified for because he lost a job through no fault of his own, and turns him instead into this experienced business person who is now in sole control of his fate and whether he has any income.
Counsel, during this period of time that he is setting up his independent business, is he also seeking employment? Because that's a requirement for you to be continuing to get unemployment, checking in with the services and things like that. So I'm assuming he's complying with that as well.
Absolutely.
He's not removed himself from the labor market.
Not at all. Absolutely. He testified that he was actively looking for work. He wanted full-time W-2 employment, and he was complying with the work search requirements. And to Your Honor's point, there are other protections in the unemployment law to make sure that somebody has not just removed themselves from the labor market to begin preparing a business, working on that business, and kind of ignoring the job market from which they came. I think the government pointed out as well that Section 401D1, able and available, provides another safety net there, as do the work search requirements under the law, right? So this section alone does not have to kind of address the question of whether that person is still connected to the labor market. One of the things that has not really been evaluated as much before this court and did not get evaluated by the Commonwealth Court majority is the fact that there's a word in the statute whose plain language, I think, just straight says cannot be squared with the positive steps test, and that is the word established, which is used in the past tense. So just based on that alone, taking a step towards establishing a business with an entrepreneurial intent, yes, cannot survive the statutory analysis, because we have to give common and approved usage. Give terms their common and approved usage. The Cambridge Dictionary defines established as accepted or respected because of having existed for a long period of time. And so we've done a lot of interpretation of Section 4 over the last 2 decades. Established is not a word that has come before this court to look at, but I think a simple look at that shows that the positive steps test cannot remain. Finally, this test undermines the remedial purpose of the law. This court is no stranger to the fact that the unemployment compensation law is remedial in nature. It's intended to provide benefits to individuals who have lost their job through no fault of their own, and that disqualification provisions should be narrowly construed so that a claimant is only denied by language that unequivocally a claimant must not be denied compensation unless he is unequivocally excluded by the plain language of these provisions. This individual was not excluded by the plain language of these provisions, and the positive steps test, unfortunately, really serves now to just expand this disqualification provision, and I think it's time for the court to take a step back from that. We want individuals to get back to work. That is the public policy of the Commonwealth. That is the point of the law, is to provide benefits while people re-engage.
Overriding public policy.
You know, I would have to plead no contest. I can't say that I followed the difference in the earlier argument. Sorry, not my area. But I think we can say that at least there is a public policy here, and that is to get people back to work. And as this court recognized in Lohman, this type of work where people are kind of more able to get access, right, to different forms of work to earn some sort of compensation, especially while they're waiting for benefits, while they're looking for a job, is just something we're going to encounter more now in this economy. And it's important that we consider that in how we evaluate these individuals. our clients and Mr. Precht want to show that they are trying, that they are making an effort to engage in the economy, to better themselves and to better their community. And what the positive steps test did, and unfortunately what the Commonwealth Court did in this case, is punished Mr. Precht for doing
It's a shame. It sounds so positive, the positive steps test. But it
it
wasn't.
does. And actually, it was originally kind of used as a way to protect people,
Yeah.
right? But it's now kind of spun in a different direction.
Okay, we understand your argument. Are there any other questions? Okay, thank you very much, Ms. Simon Michaud. Mr. Anderson? This may be the easiest case we have all week, because you two actually agree, right?
That's correct.
That's nice.
It's also the most festive neckwear.
Yes, very nice, very nice.
My wife made this.
Nice.
Is she regularly employed in the business?
She does an occasional offer of work to make bow tie, just for one client, and that's me. So.
Nice.
For which he receives no remuneration.
She's a physical therapist, so this would be a sideline business. Yeah. So,
Thank you.
good morning, Madam Chief Justice. May it please the court. My name is Caleb Curtis Anderson. I represent the Unemployment Compensation Board of Review. With me is the Department of Labor and Industries Chief Counsel, Benjamin Holt, with me as well.
Pull the microphone a little closer.
Oh,
There we go.
certainly, Your Honor.
Thank you.
As you pointed out, Madam Chief Justice, this is a case where the board obviously is now taking a position that is now in alignment with the appellant in this case. So I don't want to unnecessarily belabor the points that
Only if you want to clarify what you expect the standard to be or what you're urging us to adopt.
Yeah, certainly, Your Honor. And really, the only thing I would add to that is just that, in removing positive steps from the standalone business context, the board doesn't believe this is a sea change in how the court would interpret 402H or 4L2B. As was pointed out in Lohman, this court said that it simply wasn't compatible in the third-party context. And although there was the footnote suggesting, well, we'll leave that open for another day, what to do in the standalone business context, obviously that case has now presented itself in the form of this case, and there, as we point out in our brief, there's really no reason to treat standalone business entities differently under the law than a situation where you're looking at a claimant and a third-party putative employer. And additionally, although the board recognizes that positive steps has certainly been used by Commonwealth Court for several decades in analyzing 402H, a common theme in all of those cases really seems to be that there really isn't a dispute, if you look at most of those cases, that the individuals applying for benefits ultimately did become self-employed, would have become disqualified for benefits. It's really more a matter of timing. For example, in the Leary versus UCBR case from 1974, the claimant agreed to build houses. In the Kirk case, which was from 1981, they created a landscaping business. And sort of a common theme in all of them is there's language tucked into all of those cases where the Commonwealth Court said, look, the claimant agrees that once they started performing work, once they started building a house, once they started servicing an air conditioner unit, whatever the case may be, they would have been disqualified at that point. However, using positive steps then served to disqualify them earlier when they first, formed a corporation or, took out a loan, something like that. And really, all the board is asking this court to do is to say that, those steps are certainly things that would need to be done in order to create a business, but it's inconsistent with the plain language of the statute to then say, well, you took your first preliminary step, now we're going to disqualify you, even though no services have been performed for any sort of wages or remuneration, and that's just simply not consistent with the plain language of 4L2.
Similar to what I asked your colleague, Counsel.
Yes, Your
You
Honor.
talked about the actual operation of a customer-facing business in your.
Right.
So, similar to what I asked your colleague, does the test rely on money being in the bank, or do like receivables count? Does it matter when we articulate what the test is, or to the extent we do anything here? Should the court try to articulate a line there, or is that too fine-grained?
Respectfully, Your Honor, I think it might be difficult because, as was pointed out earlier, wages isn't defined in the Act. And certainly, whether or not you're, let's say you're, selling clothing or something like that versus providing professional services like you're an accountant or, operating a landscaping business, something like that, the line may look different, and it may be hard for this court to sort of draw an exact line, because this case, like almost any unemployment compensation case, is very fact-specific and is going to depend on the facts of this case, of each specific case. So but in terms of giving full faith and credit, as it were, to the preparatory language, the services performed for wages, there would need to be some sort of, in the traditional customer-facing business, it might be, look, I made you a pair of eyeglasses, here's, $100. That might be the line, but it might be different for a different type of product or for a different type of business. So we're not asking this court to, contemplate the infinite possibility of scenarios where that line would be, just recognizing that there has to be that preliminary exchange before we can even get to the additional prongs under Section 4L2B. And unless there are any further questions from the court, we would just respectfully ask this court to extend its holding in Lohman and overrule the use of positive steps, whether it's in the standalone or the third-party employment context. Thank you.
Thank you.
All right, thank you very much. Thank you both. Succinct and to the point. We appreciate that. Mr. Minner, we're going to take a lunch break until 12:45.
Recess
Good afternoon. We're clearing out the courtroom here. The crowd is thinning. Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Kevin Peters, representing Mr. Peters, and Mr. Jules Epstein, representing the Commonwealth, Mr. Peters.
In December 2019, appellant crashed his SUV into a van, which burst into flames, severely injuring 2 of the passengers and killing 2 others. Appellant had been drinking prior to operating his vehicle, and at the time of the accident had a blood alcohol content of 0.151%. A jury convicted appellant of numerous offenses, including third-degree murder and aggravated assault, serious bodily injury, which are the only 2 convictions at issue before us. Appellant appealed those convictions to the Superior Court, arguing that the evidence was insufficient to support the jury's finding that he possessed the requisite level of malice for these convictions. In a divided en banc opinion, the Superior Court held that the level of malice required to sustain the convictions required a showing that appellant had a conscious disregard for an unjustified and an extremely high risk that his actions might cause death or serious bodily harm. The court determined that appellant displayed this level of malice as he engaged in extremely reckless conduct over a considerable period of time prior to the crash. The dissent, however, maintained that in the DUI context, this court requires a heightened level of malice, specifically a level of recklessness that involves an awareness that conduct is essentially certain to cause death or serious bodily injury. The dissent opined that appellant's act of applying his brakes just prior to the crash supported a finding that appellant lacked the requisite malice to support his convictions and that any chain of sustained recklessness was broken. We granted review to address whether the Superior Court applied the correct standard in determining whether appellant possessed the requisite level of malice for third-degree homicide and aggravated assault in DUI cases, and if so, whether under the proper standard the evidence was sufficient to support appellant's convictions. Please proceed.
Thank you. Madam Chief Justice, may it please the court, good afternoon. Jules Epstein on behalf of Mr. Peters. I don't usually begin an argument this way, but I am going to. What my client did was horrible. What my client did was terrible and caused unbelievable consequences. And he was properly convicted of numerous charges and properly sentenced for them. As you pointed out, Madam Chief Justice, the issue here is the malice charge. And it is our contention that there are 2 errors here. One is that the Superior Court indeed departed from and in some ways disregarded or indeed disrespected clear precedent of this court. And that goes back to the language that you quoted. It's 4 words, essentially certain to occur. And that those words, which 4 members of the 5-member Superior Court majority in a concurring opinion dismissed as mere dicta, are not dicta. They are clear holdings of this court. And so the 2 matters we do ask you to address are indeed that the standard in the context of drunk driving, which is the precise language this court used repeatedly, has that essentially certain to occur, not the might language that you, Chief Justice Todd, quoted, and that when you apply that and this court's precedent, and indeed the Superior Court's own precedent, except for this case, Mr. Peters' convictions for the malice crimes, and only those crimes, should be reversed. If
this is solely based on the argument that he hit his brakes before the crash?
No, Your Honor. There's more to it than
Okay.
that. if you
Well,
want
go
me to
ahead,
turn...
take it at your own order, that's fine.
Very good, thank you, kind.
Ask you a question before you go on. O'Hanlon
Yes,
uses the language that the majority of the Superior Court uses and the dissent. Packer uses the language from the majority of the Superior Court and the dissent. So I appreciate your argument, but how can you say that either one of them deviated so grossly from the standards that this court has announced?
I suggest that that was done somewhat by ellipsis, Justice Donahue. And in Packer, where you wrote the opinion for the court, which was unanimous, and I quoted at page 5 of our reply brief, that read in context of the paragraphs together, this court made clear, and it's in the tagline, that the recklessness must, therefore, be such that life-threatening injury is essentially certain to occur. This state of mind is accordingly equivalent to that which seeks to cause injury. I agree that there are pieces of language, if you will, other clauses, where it's said slightly differently, including that might language. But if we were to look at the case, and this is what I must ask this court to do, I am suggesting that a fair reading of Packer, and it's 168A3rd at 170, that when you read those two paragraphs in its entirety, which is why I printed them in the reply brief, because I suggest my colleague did not, that they set that high standard. So I...
The page number again on Packer, the page
Yes, Your
number.
Honor, it's 168 Atlantic 3rd.
No, I have the case.
Oh,
page
170, I'm
number.
sorry.
That's all right.
And
Isn't it fair to say that we need to clarify this area of the law? I mean, if you read Packer, which cites to O'Hanlon repeatedly, and O'Hanlon uses both languages, I'm not sure they're different standards, is what I'm saying. I mean, isn't the issue here, what is the standard for malice? And we know it's not different than that which would apply in an aggravated assault case. Because we've said that. The mens rea in both is malice.
yes, and the added issue, if I may, is that, and this is what I'm suggesting the court did in O'Hanlon, reaffirmed in Comer. So O'Hanlon was 1995, Comer was 1998. We're back to this court in 2017 where you wrote, we see no reason to revisit, this remains the standard.
Which stated both standards. I mean, that's what I'm saying. I mean, I carefully read all of the opinions. You're correct. I authored for the court the decision in Packer. I don't know if we were noting a distinction. So what is the correct definition of malice and why?
So my understanding of reading those cases is that it was precisely because the court was writing, and I quote these words, in the DUI context.
Why would it be different?
And the reason is, I think, for 2 points. One is we have a legislative scheme that already includes drunk driving specific assaults and drunk driving specific homicide. And all drunk driving is arguably reckless. So that the court was acknowledging, as I understood it, both because we exist in that statutory scheme and because the horrible prevalence of drunk driving, that for the rare case to be drunk driving malice murder, it had to be at that extreme because otherwise it doesn't pay respect, my word, to the statutory scheme and doesn't acknowledge the problem that we would swallow up all of drunk driving in it.
Well, except we took care of that problem by saying merely driving drunk is not malice.
Right.
I think we took care of that problem.
Right.
Correct?
And so you took care of it by saying that's it, I'm going to call it the low end, right? That's what's not. But to say what is, it has to get to that level of certainty.
The facts in this case are such that the defendant was driving, I believe, on I-95, removed his eyes off of the road, was 2 times the legal limit, and was traveling at 115 miles an hour. How do those facts not comport to your definition? You said,
Yes.
you're quoting the recklessness must therefore be such that life-threatening injury is essentially certain to occur. And it in fact did.
And it in fact did. And if we were to work backwards from it in fact did, that's different respectfully from was it essentially certain to occur. And here's why, Justice Doherty. There is no question that in those last 5 seconds, because that's all that the black box or event data recorder can capture, his speed was up over 100. It talked about 115, 113, 106. Any of the numbers is absurdly high for 5 seconds. We do know that the very first witness who testified at trial, who was actually the last person to see Mr. Peters drive just before the accident, said he was speeding, but gave no description like that. And what appears to have happened, and the Commonwealth seemed to have accepted this in their closing argument, it was apparently as he bends down, looking for his phone, stupid, unsafe, reckless, that I guess he put his foot down. What we also know is there were no prior warnings, and I want to make clear as I turn to that.
What do you mean, no prior warnings?
Okay. One of the issues that came up below and is actually acknowledged in the decisional law here is it is, I don't want to ever say more reckless, but a constituent part of the recklessness analysis is who was on notice of what.
So no one said to him, gee, Joe, you shouldn't drive because
Exactly.
you're so drunk.
Exactly. Which is contrasted with Packer, where Ms. Packer was personally on notice, having huffed, right, snorted cleaning fluid before. She knew, if I do that, it makes me unconscious. I'm going to do it anyway. And Justice...
It's not equivalent to say, I'm going to drink alcohol and get in a car on I-95 and drive at least 100 miles an hour as I look for my phone on the floor. You don't think that's certain to occur? Who needs to tell you, stop, don't do that?
I did
Maybe
not...
the guys that got killed.
Justice Doherty, I agree with you about the tragedy. That's where I started. In other cases, and Comer is the best exemplar, in Comer, it was speeding on Roosevelt Boulevard in Philadelphia, much more highly trafficked than this area. Comer, this was I-95 somewhere in Bucks County at about 12:30 or 1 in the morning, where even the video capture of this does not show it highly trafficked. There was some traffic. But everything you're saying respectfully is often what happens in drunk driving. And that's why I talked about there wasn't a warning. And at least in some of the cases, the fact that the person never attempted to brake was also considered a pertinent fact. We do know that there was an attempt to brake, both from the electronic data recorder and from the fact that it wasn't head-on, that there was this at an angle.
I
Justice
thought the
Mundy.
record
sorry.
reflected that early on in the evening, when the work party broke up, that somebody suggested they give your client a ride home, and that could be considered as a notice.
So that was what the Superior Court majority classified it as. The actual language, and I'm sorry I don't have it memorized, was not anything like, I think you should come with me or something. It was, hi, I'm going back to Bucks County. Do you want to ride?
And the person offered others rides too.
Made the general offer. So Justice Mundy, maybe? And I don't mean
Well,
that.
the facts are the fact as found by the trial court, but I just wanted to say that likewise with your analogy on the braking, certainly he could have been braking for his personal reasons as opposed to conceptualizing the harm he was and the danger he was placing the people that he ultimately wrecked into.
I don't think that was his testimony, but I certainly understand the court's point.
Based upon your request for us to accept this proposed malice standard, what sort of DUI injury or death, aside from Packard, can you imagine that would satisfy such a standard?
So we actually cite cases in our principal brief where the Superior Court found more facts, and I'm sorry I don't have them all memorized, but I think one is called PIGG, P-I-G-G, where there was warning and the person persisted. There's one where somebody was in the crosswalk and the driver saw that and sped up towards them. So there are cases where people persist despite warnings.
Are those all cases where the driving was ongoing? Because are you making the argument that conduct before one gets behind the wheel is categorically irrelevant? Or would you concede that there could be facts, hypothesize a situation where we also had in the facts that your client admitted, verbally that he was too drunk to drive in these, around when he removed the parking barrier, et cetera, that he admitted to others that he knew he was too drunk. Could that be in the calculus here?
Absolutely. There's no... Where I disagree with the Superior Court, Justice Wecht, is their thesis that he was reckless from 8 o'clock that morning when he chose to take his car to work, knowing that there was a party that night. That distance, to me, is too far. Once he's drinking, certainly things he says, things he does, things he is told, could fairly contribute to the recklessness analysis. We don't disagree with that at all. We say that when you line this up with, again, I cite to Comer's was particularly egregious, and in other cases, after Comer, actually a case called Del Vecchia, which was decided the same year as Comer, the Superior Court said, there's not enough here, and that person was speeding with a .191 or some higher than my client's level.
Where does wanton behavior fit into this? Where does wantonness fit into this spectrum? Would you concede your client's conduct was wanton, and does that equate to malice?
Not having the
depraved heart indifference.
Depraved heart.
Taking you back to the classroom here, Professor.
Thanks. And so my answer is two parts. That was actually part of the jury instruction here. So what happened is that the trial judge instructed on the three different definitions of malice that we have in the Pennsylvania suggested standard jury instructions, none of which is the language of essentially certain to occur. So one could make an argument if this were decided under that standard, and that goes back to a case called Commonwealth versus Drum, which is the historic origins of the malice standard in Pennsylvania, that yes, our argument has been and remains, and Justice, forgive me, 4 members of the Superior Court, led by now President Judge Lazarus, seem to agree, is that this court's precedent set that to the side, my words, not hers, in a drunk driving case, because in that context, and it goes back to what I tried to explain when responding to Justice Donahue's question, It was to separate this out from the recklessness inherent in drunk driving in a statutory scheme where we already have, and I'll say its name wrong, but it's homicide by drunk driving as a statute.
Counsel, but help me understand, please, the line between ordinary drunk driving recklessness and this other level of recklessness that you're talking about, that you say our case law. I mean, I'm having a hard time figuring out what set of facts get me past ordinary drunk driving recklessness.
So there are some analogies in the cases, and then I'll actually try and do what I watched people try and do, not necessarily successful today, give you a test.
Ah, that's great. I like tests.
I will try, okay. But there's language in there like Russian roulette, something like that, where we know in the context of the driving and everything else, that, as in Russian roulette, there are only 6 times somebody's going to die. And so if the circumstances were such that this person were driving in the middle of the day outside of a school where they knew they were outside of a school, and I realize I haven't given you a test yet, but I'm trying to do it first by example, that we would say you have to be on notice at that point. The streets are so crowded, the situation is so bad, and to go back to the language, life-threatening injury is essentially certain to occur.
But your distinction, I appreciate that you're, providing an example to illustrate, but I think it's a thin reed, because to say that the law would recognize a distinction of this significance between, as you said, driving down an urban street that has a school or something, and careening around I-95 at any hour, it's uncontested. There were cars there. These 2 people called in 911. He narrowly missed one of them. Why is that not akin to Russian roulette? It may be there are, maybe there are more chambers in the barrel in this version of Russian roulette that are empty, and fewer in the other version. But it's still Russian roulette, isn't it? It's gonna happen here, right?
I wish I could answer you scientifically.
He's not driving around. He's not doing wheelies in a farmer's field.
Agreed on that, and we're somewhere in the middle between farmer's field and incredibly crowded street. But I go back to this court's decision in Comer, and I say respectfully, I'm hard pressed, but that's obviously just my opinion, to say that Comer, who not only drank, which is legal, but also used drugs, and then gets in the car and is driving, now not at 110 or 106, but at 70 in a 45-mile zone on Roosevelt Boulevard, which at all hours of day and night, I would almost ask this court to take judicial notice of it. I live near there. It's crowded as
Yeah, but Counsel, but I'm still struggling. I know you didn't get to the test. You're almost, and maybe my issue is with the court's precedent on this. I could make an argument, maybe nobody would find it persuasive, that engaging in drunk driving as an adult, getting inebriated, getting behind the wheel of a car is malice, period. I could make that argument. And I realize that sort of runs counter to some of our precedent. I realize that. And it also doesn't necessarily make a lot of sense when it comes to the different gradations of DUI and things like that. But what I'm having a hard time is trying to ascribe some kind of an intentional voluntariness to someone who is inebriated, who is intoxicated and can't drive. I'm supposed to look at, well, did they know that if they drank they were going to get drunk and hit people? Did they know that they can't drive while they're intoxicated? I mean, did somebody warn them by drinking and getting behind? I mean, this is all stuff that seems to me to be intuitive. with drunk driving.
So I'm going to have a long answer if that's permissible.
Except for the fact, I thought Justice Weck's argument, or Justice Weck's fact pattern was very interesting, though. If you're doing wheelies in a field where where no one reasonably would expect a person to be,
Right.
and in the course of doing that, some farmer's walking out there and picking some corn and they get hit. That's probably not malice.
Right.
But that's not what we have here.
Agreed. So, to take it from the top, so to speak, okay? If this court were to now say all drunk driving is malice, or whatever we said in those cases was indeed the rule of law, but we got it wrong, we're now realizing we misinterpreted, Mr. Peters, I would suggest respectfully, is entitled to the law as stated. Because we can't go backwards and reduce a standard, assuming I'm correct of where the standard is. But this court ruled 20-something years ago, almost 30 years ago, that drunk driving third-degree murder or drunk driving aggravated assault malice needed more. And all drunk driving is dangerous. Some things are dangerous, arguably below the level of malice. And so the court, the formulation I am asking this court, my words, and I realize I may be presumptuous here, to stick with, if I'm reading that Packer case correctly, is in the context when you were driving drunk that day, did this meet that essentially certain to occur standard? And if it turns out that that's wrong, and prospectively the law shouldn't be that, I would again urge, that's not fair for Mr. Peters if that indeed is what this court meant in O'Hanlon, Comer, and Packer.
I know we can't change it for your client.
Right.
Prospectively, should we go back to first principles and put aside the precedent for a moment and look at the statutory language about offense defined? Reckless, intentionally, knowingly, or recklessly, under circumstances manifesting extreme indifference to the value of human life. If we just applied that without reference to judicial overlays, does that put your client in a more precarious situation, or people like him in the future?
People like him in the future, yes. There's one tiny problem, I think, Justice Wecht, and that is, and forgive me, I can't do this without writing it out. I'd have to overlay that language from the aggravated assault statute with drum and the various definitions of third-degree murder malice. I'm not sure that, and I may be wrong, I would have to process that for a minute, whether the language of 2701 that you're quoting is actually third-degree murder malice language, which O'Hanlon said they should be the same.
Yeah, that's what I was going to say. Do you not concede that they're the same?
I have to actually write that out or reread the definition.
If they are if they're the same, then perhaps we've gone astray.
And
perhaps going forward, it wouldn't apply to Peters, but perhaps going forward, we would then say, just look at the statute. And reckless under circumstances manifesting extreme indifference to the value of human life would look a whole heck of a lot like what he did on 95. Would you agree?
I would probably debate the extreme, but certainly indifference.
In Malone, were we not interpreting the aggravated assault malice standard in Malone, the Russian roulette case?
I apologize, I don't recall.
Because in Malone, we said that it's an act intentionally done in callous disregard of its likely harmful effects on others.
I'm sorry, Justice Donahue, I'm not prepared to.
And what's wrong with that definition? Likely harmful effect on others or another.
Likely.
Harmful effect.
And again, I'd have to line that up against the drum traditional, and I'm sorry, without having it written out in front of me. If the
Drum is shooting into a crowd. Is that the drum case?
I believe so.
Yeah, well, that would be likely an intentional act, shooting a gun,
Right.
in callous disregard of its likely effect on others.
And
I mean,
again,
we're here on a charge to the jury, right?
yes.
That's what you want us to straighten out here.
Well, I'm not here on the charge to the jury, actually, because there was no objection made to the charge to the jury.
Okay?
So this is purely a sufficiency claim that upon review, whatever the jury was instructed, do these facts, again, we're back to step one, what is the test? Step two is under that test. If I'm wrong about the test, the case is almost certainly over. If I'm right about the test, then we come to the issues that Justices Doherty and Mundy were asking me about these particular facts, and the facts I would respond with, that no one sees him walking, staggering. We have plenty of videos with him, although we also have the video of him doing this weird thing with the gate in the garage.
Are you saying because he didn't know he was drunk?
I am saying that he knew how much he drank.
Right.
He was not if somebody is walking around falling down, it's a contradiction.
Somehow, so I just want to make sure I say, so we would have a different case if he was so inebriated that he couldn't control his body functions and probably had no idea what he was doing.
I think that's
But
right.
that rises to malice when he had no idea what was going on?
Because hopefully,
How would you get to malice? That's a mens rea, it's a state of mind. He's completely inebriated, falling down, and we're going to ascribe a greater level of level of recklessness?
because in Pennsylvania, we do not allow voluntary intoxication to negate mens rea.
Agreed. He was voluntarily intoxicated.
Right, but you were asking if someone was so drunk that they're falling over, therefore they're not realizing it. We don't give anybody that out, is my understanding.
Agreed.
under voluntary-
Explain to me, though, why the falling down drunk translates it from recklessness to malice. That's what I don't understand. I mean, I think Justice Donahue asked the question about drum.
Mm-hmm.
I could make an argument, again, maybe not very persuasive, that drinking heavily, being intoxicated as the law would define it, getting behind a vehicle, getting onto I-95 at any time of the day is just as dangerous as shooting a gun into a crowd. You're playing with lives.
People are playing with lives every single time they drink and drive. I cannot.
Well, but maybe somebody's not doing it when they're doing wheelies in a field. But when they get onto I-95, that's what makes it, that's what takes it from couldn't possibly have happened. Who would have seen this? Who would have seen that they would have driving their car at 3 miles an hour through a cornfield to try and get from the road to their carport, and they hit somebody in the middle of a cornfield? Versus, I'm going to get my car out of this garage. I'm going to drive on I-95. Everybody knows there's cars. It's not like I-95 closes down.
But the same would be true of Roosevelt Boulevard, too.
That's right, and that's why I come back to this court's precedent, which would presumably inform the legal sufficiency standard as it should apply to Mr. Peters, as opposed to perhaps prospectively. I'm happy to answer other questions of the court. I come back to the language and why we wrote in detail in our reply brief of using the full context of your words, Justice Donahue, from Packer.
Which was from O'Hanlon,
Which-
which also used the same standard that the majority of the Superior Court used. Therein lies the problem.
Except I'm suggesting that
We were not attempting to make new law in Packer. We started out by saying we are reaffirming.
we are reaffirming O'Hanlon and Comer, and if we go back to them, that's where this language came from.
But so does the language that the majority of the Superior Court used. It also came from O'Hanlon.
So, and Justice Donahue, if the court determines that,
I'm being blunt with you.
Yes.
I mean, I think if you're looking for clarity in the precise language that's coming from these decisions, I just don't think it's there. I mean, I think both are used. I mean, my question to you at the outset was, does it make a difference? Likely to cause, or what the Superior Court said, may cause, given the prefatory language to it?
and my answer is, I don't know why this court then added in, particularly when it was focused on drunk driving and the dilemmas that we face on what is the continuum of recklessness, why this court said, I would suggest emphatically, and was included in that later quote in Packer, and it's right here, so please bear with me, essentially certain to occur, a state of mind that is equivalent to that which seeks to cause injury. And I don't know that those words were, I hate to use that phrase, mere surplusage.
I understand the nuances that you're drawing in drunk driving cases, but I think as that law developed, we were trying to be very careful to not impose a different malice standard in aggravated assault cases and the drunk driving homicide case that we have here. I think we were trying to be very careful that malice was malice under those two different statutes.
And I accept that, and all I can say is, for some reason, the court included, my paraphrase, the virtual certainty.
Well, I'm not certain that's different from what I suggested earlier. Malone said is likely, of its likely harmful effects on others. Likely harmful effects.
To me, essentially certain to occur is different from likely, but that's, I'm not.
Would you
I'm
agree
one
we've
person.
perhaps said too much?
Yes.
We've said too much in our effort, in the court's efforts over the decades to bring clarity. We perhaps have rendered something less than clear?
So many years ago, I argued a case, and Justice Bayer said, Mr. Epstein, would you take off your advocate hat and put on your professor hat and give me the answer? All right? Luckily, it was the same that day. My professor hat says, they're a little, and I mean no disrespect, but they're, because of all that language there, whether we call it a little messy or a little extra verbiage, that everyone who wants can find what they want in it, is a fair way of saying that. But for some reason, talking about, by example, it's like Russian roulette. It's like driving into a crowd of people, to me, was an attempt to define it precisely because of the epidemic nature of drunk driving.
How fast was your client driving when he decided to reach over and try to find his telephone on the passenger seat of the car?
I think it's fair to say, and I'll defer to my colleague, I don't know if that was in the last 5 seconds or shortly before the last 5 seconds. So it may have been he bent and then his foot presses down on the accelerator. We only know the last 5 seconds, and it's hard to say, was it at second 5, was it at second 6, second 8 when he made that reach. Again, all I can do is refer you to the testimony of the very first witness at trial, who was an ambulance driver who was driving along, saw him pass, and he was going very fast. Those are not the, maybe it was extremely fast, but never said anything like this was like, forgive the words, bat out of hell, right? The proverbial cannonball. That's the best I can answer you. The record is not clear.
All right, Professor Epstein, thank you so much.
Thank you for your kind attention.
Let's hear from the Commonwealth. Mr. Lutis.
And please correct me if I was wrong.
Madam Chief Justice, members of the court, Timothy Lutz on behalf of the Commonwealth for Bucks County, Pennsylvania District Attorney's Office. Your Honors, at this point in time, I think the line has been said was the first thing on my notes. Malice is malice. Malice has always been malice. Malice has been defined and was finally defined in the end of the Packer decision by Your Honor, saying the standard for malice enunciated and done, reiterated in O'Hanlon and reaffirmed today requires recklessness of consequences and the conscious disregard for an unjustified and extremely high risk that a chosen course of conduct might cause a death or serious personal injury. That has been said many times over the years.
Do you think might was a misstatement? Do you think the word might was a misstatement?
I don't believe so, Your Honor, because looking at other
From
cases,
O'Hanlon. It's a quote from O'Hanlon,
that is the final holding in Packer that Your
Right.
Honor wrote, yes.
which
Do you
is a quote
think,
from
do
O'Hanlon.
you think that was a mistake when we first used it?
To say might? No, Your Honor. Because if we look at the other cases through over the years, the intentional act of doing an uncalled for act in callous disregard of its likely harmful effect on others, the grossly reckless conduct which he should have known was likely to result in serious bodily harm, might and likely, these terms are used over.
Well, a lot of things might happen, right? And a lot of things that might happen are not likely to happen.
Right.
I'm just probing the holes that might have opened up in the jurisprudence over all these, iterations of the standard judicially.
I would think that there might be different phraseology by the court or different nuances as to which to use, but malice has always been the same thing, which malice is that action that this court has relied on over the years of what it needs to be with that risk.
The what? The what?
The extremely high risk with the knowing the risk and disregarding it with the might or likelihood that it was going to happen.
Well,
but the court has specifically said.
Which is
They're
it?
two different things, aren't they? Might
Yes, Your Honor, but in due respect, Your Honor, it's the court's language over the years that has been that way.
Oh, I understand that, but it's been many things over the years. Malone uses the phrase, malice is malice. You started out with that. I think we've said that. I'd have to look again at the difference in gradation that might cause a different conclusion or whatever your opponent's well-stated argument was. But certainly Malone, which is a pure aggravated assault malice case, uses the phrase of its likely harmful effect on others. Do you agree that the standard should be the same?
Of course, Your Honor. Malice should be the same regardless, and I think that's where I differ in opinion with Mr. Epstein in regards to there being a different standard of malice versus driving under the influence offenses and different standards. Malice can't have more than one definition. There can be the nuances and different phrases and choices with that, but you cannot have a DUI malice. You can't have an aggravated assault malice. You can't have a third-degree malice. Malice is across the board the same exact thing.
I don't think Mr. Epstein is necessarily arguing that that's a bad thing to have the same definition of malice across crimes. I think what he's arguing is if you want to do that, don't hold my client accountable for what seems to be messy? Is that messy language? Messy language that on one hand said essentially likely or essentially certain, which you can't divorce that language, you can't excise that language out of the opinions.
Yes.
And likely. And he's saying, go ahead and fix this if you want to fix this, if you think it was wrong. But my client still deserves relief. What do you say to that?
I think at the end of the day, the essentially certain language, regardless of what this court would choose to use if you were going to alter whatever the definition of malice is or what you believe it to be, we would meet that essentially certain language. in this case.
And why is that?
Your Honor?
Go through, what facts lead you to that conclusion, or is there really only one fact that makes a difference here?
Your Honor, I would
Taking
believe...
your eyes off of the road and reaching over for your phone when you're going at a very fast rate of speed.
Your Honor, I would say, and I know Mr. Epstein took issue with this, that the events leading up the entire day is how I explain everything in the brief and how we've explained everything from the beginning of his choices. Those are all factors in the ultimate totality of circumstances viewed in the light most favorable to the Commonwealth, that when we get to that moment of him getting behind the wheel, him breaking the gate because of his intoxication, because of his decision and malicious act to keep going, to almost hitting the two cars, or to hitting the one car, the two 911 callers, the driving, the three most important things in this case, Your Honor, is the .151, it's the 115 miles an hour, and it's a decision that he made to take his eyes off the road. He purposely made that decision to take his eyes off the road, to look down, reaching within his bag to find what he was looking for. No one needs to tell anyone that they shouldn't be taking their eyes off the road while they're going 150 miles an
So
hour.
if he hadn't have done that, and he had gotten in the car, and he had gotten on I-95, and he was driving down, and he was the most attentive drunk driver you have ever possibly imagined, like was absolutely locked in, you know I'm loaded, I don't want to hurt anybody, but, you know, somehow, some way swerves and, you know, hits somebody who's walking on the berm. Is that malice?
I think it could be.
What's the fact in that fact pattern that takes it away from ordinary drunk driving?
I think in that fact scenario, this court and the Superior Court has repeatedly said that driving drunk alone is not malice.
Right.
So in your hypothetical, Your Honor, that only leads to a slight deviation or something along those lines. It wasn't that he was perfectly driving. This was the decisional choices that he made. I suppose actually in your circumstances, Your Honor, he's making more of the affirmative decisions to do things, such as Mr. Peters did in our case.
That's malice?
I'm just saying as far as active decision making.
Well, I'm trying to figure out what the difference between normal drunk driving that leads to death and malice drunk driving that leads to death. And here you're saying it was sort of a confluence, but you do focus on the idea that while he's driving drunk, he moved his eyes away from the road, grabbed the phone, and, oh, by the way, if anybody shouldn't do that, nobody should do it, but drunk drivers certainly shouldn't do that, and that's what gets us to malice. I'm saying that didn't happen. He was the most attentive drunk driver you could possibly imagine and still killed somebody. Does that rise to malice?
I don't know for certain that it would, Your Honor.
So it's not just the it's in a, yeah. So following up on that, in Justice Brobson's hypothetical, it wasn't the driving drunk on Route 95 that was the Russian roulette aspect. It was the fact that Peters, in your view, was not the most attentive drunk driver. He was a careless drunk driver.
No, Your Honor. It would be, with Peters, it was playing Russian roulette.
It was what?
It was playing Russian roulette. Him driving down the road, not looking, being that drunk, not paying attention, increasing his speed as he was bending over. His speed increased. We don't know more than those 5 seconds out, but we know that as he was leaning over, which his last words were, as he was testifying, I looked up and the car was there.
Yes,
His speed was increasing.
You've eloquently articulated the facts. I guess the follow-up question I would have it, do you think the legal standard we have is adequate, is adequately clear?
I think the definition, yeah, I think it would be clear for this case, yes. I think it's clear. I think malice is perfectly defined as it is. I understand that there are differentiations, but the final holding of this court within Packer saying the likely and the might, it all reaches the same level standard of malice that malice exists
But it
as.
doesn't, really. Likely is very different than might. Likely to cause versus might cause are two very different things.
Okay.
I mean, I could make an argument that driving drunk which means you don't have the reaction time that you otherwise might have, but nothing more than a split-second delay in putting on the brakes. That wouldn't be malice. That's driving drunk and having a reduced reaction time. That's different than doing that is likely to cause harm to another.
I think with the likelihood, though, with the facts of the case and him driving down the highway where there were cars, where he almost ran into the cars, where repeatedly and over the circumstances, he was playing that standard of Russian roulette. The likelihood of him causing that injury was clear and going to happen because of everything that was going on with him on that time period. With the driving drunk, the speeding, he was going that fast. All three of them combined together is what gets you there.
All right, I think we understand. Do you have anything else that you wanted to add?
Just a few things, if I could. One of the things that was focused on by the en banc panel and the dissent, and that was mentioned briefly today, was the decision to the braking. One of the focuses was by the dissent that the brakes were applied. One of the issues that was used by the Commonwealth is that he applied the brakes at 0.4 seconds before the accident. My argument is that is effectively not braking at all at 0.4 seconds. In terms of that as well, that doesn't take away, him hitting the brakes doesn't take away the malicious act that occurred that caused the accident. That would be me shooting into a crowd, into a crowd of people and trying to reach out and grab that bullet before it hits somebody else. That doesn't take away the moment that I made that decision to shoot that gun into a crowd of people. So I think the focus on and viewing the braking...
There are two different parts of the malice standard. An intentional act is the first part. You're talking about that's the first part. The second part is that intentional act likely to cause harm to another?
Yes. Which is the same thing which was happening when he was intentionally driving down the highway on 995, when he intentionally took his eyes off the road and was intentionally going 150 miles an hour. He didn't need anyone to tell him to not do any of those things because all of them were improper. All of them he knew was wrong. And as his own testimony said, I thought it would be okay. That's a reflection upon himself that he knew when he was doing that, I think it might be okay, but knowing that he shouldn't have done it. In light of the Peters, in the circumstances of this case, I would ask that you would affirm, Your Honors, the decision by the en banc panel of the Superior Court. I believe that there was enough to show with the totality of the circumstances and the light most favorable to the Commonwealth that Mr. Peters did act with malice when he was driving on those days, thus committing the 2 third-degree murders and the 2 aggravated assaults.
Thank you. Thank you both.
Thank you.
Mr. Minner, we'll adjourn for the day.
Thank you, Counsel.